Okay, good morning. The Medical Board of California Panel B meeting is now called to order. Can we have the roll call, please?
Morning and welcome. Dr. Donadev?
Here.
Dr. Levine? Here. Ms. Pine? Here. Ms. Shipsky? Mr. Tagami?
Here.
And Dr. Lowe?
Here. Okay, the first case that will be heard will be the oral arguments on the petition for reconsideration from Enrico Melson, MD. I'd like to turn the proceedings over to our judge for the morning.
Thank you, Doctor. Okay, let's go on the record. Okay, this is, my caption reads, in the matter of the accusation against Enrico Antonio Melson, MD, physician and surgeon, certificate number G59473. This is case number 17-2011-212848, but as Dr. Lowe mentioned while we were off the record, this is a time for the presentation of oral argument relating to the board's decision to reconsider the decision in the matter which I have identified. My name is Carl Engemann, Administrative Law Judge assigned to hear this matter, and we are convened in Sacramento on July 18, 2013. And even though we have had a roll call, may I, starting from my left, have the panel members identify themselves for the record, please?
Philip H. Tagami.
Sharon Levine.
Dave Donadev.
Denise Pines.
Okay, thank you. And may I have the counsel identify yourselves for the record, please?
Good morning, Cindy M. Lopez, Deputy Attorney General for Complainant.
Thank you.
Good morning. Jason Ross, representing respondent, Dr. Enrico Melson.
Okay, and Dr. Melson is present, correct?
Yes, Your Honor.
Okay, thank you. All right, I think the parties know that the protocol established by the medical board, and this is panel B, is to allow 15 minutes of argument for or by respondent's counsel, followed by 15-minute response by the Deputy Attorney General, and then 5 minutes beginning with respondent's counsel for rebuttal argument, and concluding with 5 minutes from the Deputy Attorney General for her rebuttal. You know, in the past, it's been useful to have just a brief summary of how we got where we are. Are you, Ms. Lopez, are you inclined to provide that to the panel?
Sure.
Okay, thank you.
This will be very, very brief. This is a very straightforward case. About 2 or 3 years ago, the respondent pled guilty to a violation of the tax code for failing to file income tax return with the intent to evade payment. He pled to that, and he was put on criminal probation. He was put on formal probation. We filed an accusation. It went to hearing in several months ago. He was the only witness. The ALJ found that we proved the case by clear and convincing evidence. The ALJ then issued an order which had no, and I repeat, no probationary optional conditions, just the standard conditions, 5 years probation, that was it. And then respondent filed a petition for reconsideration. He's asking the panel to lift the prohibition of supervising physician assistants. It's a very standard term, and the panel granted the reconsideration. To be honest and straightforward and direct, I'm not sure why it was granted, but that's how we got here today.
Okay, thank you very much. All right, Mr. Ross, please.
Good morning, everyone. Thank you for allowing us to be here to have this matter reconsidered. I know that case law pretty much says that a conviction is directly related to the practice of medicine. In this case, we believe that this is a very unique case where Dr. Melson's conviction is not substantially related to his practice of medicine. Dr. Melson has been practicing for over 31 years with an emphasis in global integrative medicine. Over the 31 years, he has had very little encounter. I think he's had one incident that was resolved as far as any blemishes to his record as far as malpractice goes, and he can explain that. But the conviction related to evading taxes with the intent to defraud. He had never had the intent at the time of his plea bargain. One of the things, and I know it's not here to be considered, but we are in the process of appealing that because he did have inadequate representation in which led him to take the particular plea. Dr. Melson was in the country at the time. He was traveling from New Zealand, and the person who was representing him was suspended from the practice of law not too soon after his plea bargain for use of drugs. So that person, even at the time, Dr. Melson did not know. So that is one mitigating factor, was just in him taking the plea, he did have inadequate representation. So when he was explained what he was pleading to, he was under the impression that he had no intent to evade. He knew he was late on filing his taxes, so it was more of, okay, plead to this. He's in jail. He needed to get back to New Zealand. He was in the country. When he found out that there was a warrant for his arrest, he immediately made accommodations to come and deal with that. So he was actually met by the officials, which was prearranged. His arrest was, his surrender was prearranged. There was no running. There was full cooperation. The only challenge was that he was not, even though it may have been explained to him, but his attorney did not fully explain the ramifications of taking that particular plea. So one of the things that's very crucial is part of his plea was to pay restitution. However, the restitution was based upon what was a default calculation by the Franchise Tax Board. Dr. Melson had a tax obligation, a default tax obligation for over $955,000 in the same year in which he pled in 2005, which this stemmed from. When that obligation was reviewed by the Federal Tax Board, or the IRS, that $955,000 obligation was reduced to $126.78. When the Franchise Tax Board reviewed, well, basically, we're having a challenge even right now in dealing with the Franchise Tax Board. Because of him taking the plea, the $139,000 or so that is claimed to be owed is based on the default, but is tagged as restitution, but not necessarily something that has been reconciled by the actual tax board. So I think these are points that need to be understood because Dr. Melson has never been one to, although he may have been responsible for filing taxes late, he has never been one to purposely or with the intent to evade taxes. The actual event or the tax year in question is 2005. The conviction was in 2011. One of the things that we noticed, or that was in the previous administrative law judge's decision, was how the degree of the punishment was evaluated. So one of the things that some of the factors based on the California Code of Regulations, Title 16, Section 1360.1, provides that if a physician is convicted of a crime, the criteria for evaluating rehabilitation are the following: 1, nature and severity of the acts; 2, his total criminal record; 3, the time that has elapsed from the crime; 4, whether the licensee has complied with terms of parole or probation and restitution; 5, any evidence of rehabilitation. So they went through each, the ALJ shows that he went through each factor. He found that the conviction was recent. However, the conviction was recent, but if we're talking about the crime itself took place in 2005, some 7 years ago. The nature and the severity of the crime was moderate. So crime versus conviction, moderation, is it based because it was 139,000 old? I'm not sure exactly how he got moderate, but he did not get severe. And this is his only criminal offense. And there was no evidence that he was non-compliant with probation, which he's been complying with all terms of his probation. And a key point is that there is no evidence that he has ever endangered the public. One of the key things that we're disputing in the punishment is his non-ability to supervise physician's assistants. And the probationary period in which was granted is 5 years, but it's 2 years after he's even on for his criminal probation. So we think that the probation period is much more, the timing is too long if the probation has to stay at 5 years. One of the things that is a big challenge right now is this has been impeding his ability to seek work. A lot of the positions that he's has applied for and been considered in being employed is a key factor in him being able to meet his obligations to his children, his obligations to even pay the restitution that is required of him if he is unable to obtain, if he's unable to be gainfully employed. So I've done a little bit of research. It was very difficult to find here in California where where there are facts similar where we have letters of reprimand, but in other states and other places with the charges that were even more severe related to tax evasion, only a letter of reprimand was granted. We think with Dr. Melson's substantial history, most of Dr. Melson's work has not been money motivated. And that's part of the challenge that we're here. Most of his work has been in the indigenous communities. He's well known, he's traveled, but mainly practicing for the greater good of humanity. And so, whereas it is understandable that, you know, he may have in the past placed little priority as far as financial, he is definitely remorseful, understands the importance of filing taxes. Most of even the taxes over the years, he's had very little obligation to pay back to the Franchise Tax Board as well as to the Federal Tax Board. He lives a modest lifestyle. He is one of the main things, even in part of the petitioner's filings, is that they found that he was competent and a caring physician. So to be punished so harshly, we think that this is a very unique situation that should be reconsidered based on the following facts that we presented.
Okay, thank you. All right, your response?
Yes, good morning. I find it interesting that counsel starts his argument with the issue about this conviction not being related to the practice of medicine, and I want to quickly put that aside. First of all, this was not an issue that he even raised in his petition for reconsideration. The judge found that it is substantially related. There's actually a case right on point. It's called Wyndham. I apologize, I don't have the case site. But literally this exact same conviction has been found to be substantially related. That's not really the issue in this case. And again, this is based on the petition for reconsideration filed by respondent. The issue is, should this panel lift the standard condition of not being able to supervise physician assistants? So let's talk about what he was not given. As a panel is aware, there are model disciplinary guidelines. You vote on those. You're the one that sets those. Those are the guidelines that every DAG, when we call our settlement person and talk about settlement, that's where we start. Now, they are guidelines. This is not the law, they're not required, but it's a place to start. Now, you can stray a bit from the guidelines if there's aggravation. In other words, you can give more discipline than what the guidelines say. Or you can stray a little bit if there's mitigation. In this case, excuse me, in this case, these are the minimum guidelines for a conviction such as this. Community service, he was not given that. Ethics course, he was not given that. Psych eval, he was not given that. Medical treatment, he was not given that. So far, that's 4. A billing or practice monitor, he was not given that. Solo practice prohibition, nope. Prohibited practice, no. And victim restitution. I just said 8 conditions from the optional conditions in the guidelines that respondent was not given. And now he comes before the panel, not only is he given, in my experience, the most lenient discipline I've seen for a conviction case, and I've been doing this, I can't even believe I'm going to say this in public, for 20 years, but I know, I look so much younger, you're shocked. But he's now saying, not only do I not have these 8 optional conditions, but I want you to lift a standard condition. Standard means standard. It's a condition in every single probation case. It's a condition in every case where there's a stipulation, where there's a hearing. I do understand his problem in getting a job, and I do have to say, this is a respondent that is a little bit different than many of the respondents I have seen. He's not motivated by money. He does want to give back. He does want to work in communities where patients are usually not given great care. The problem is, he has this conviction. And the ALJ did not even write in his proposed decision why he strayed, why he didn't give one single condition. Another issue, counsel again, not only started with the irrelevant, no disrespect, issue about this not being substantially related, the plea. We're not here to talk about the conviction. He pled to what he pled to, which is with intent to evade paying taxes. It doesn't matter that his counsel was incompetent. That's not relevant. When you plead, you're not allowed to then come before the board and attack the conviction. Counsel also comments about comparing this to other cases. I can tell you that if you look in the action report and you compare this to other cases, doctors do not get PLRs for a conviction such as this. The reason why this is substantially related to the practice is the idea of honesty. If you are purposely evading taxes, you're not the kind of person that the public maybe can trust. If you're evading taxes, what are you going to do when you file insurance claims? What are you going to do when you meet with a patient and maybe you're not honest and truthful? That's why this is substantially related. That's why there are so many conditions when someone gets a discipline like this. He says that he's punished too harshly. Again, going back to my issue, he is being punished leniently. And I'm sorry, I shouldn't even use the word punish. He is being given a lenient discipline. And with all due respect, and again, to be very direct, if this panel adopts what respondent is asking, and you lift this standard condition, this is going to set a very bad precedent for other cases. I can tell you that respondents and respondent counsel, they talk to each other. They know about these cases. And if you, for reasons that I would not understand, if you lift this and don't even follow this very minimum discipline, then it undermines my ability, my colleagues' ability, when we go in front of OAH, when we negotiate settlements with other respondents, it undermines our credibility. Because if they know that they can just file a petition for reconsideration and the panel is going to completely stray from the guidelines, why would they ever settle? They wouldn't. They're guidelines so that we can start start at the same place in these kind of cases. They're guidelines so that you can be consistent in your discipline. So it doesn't matter if a doctor is in LA and has his conviction, or San Diego, because we have these guidelines, they should be consistent. Again, and if Dr. Melson speaks, you will see that he's very sincere, but on the four corners of this decision, there really is no justification for lifting this PA prohibition. Thank you.
Okay, thank you. All right, Mr. Ross, you have 5 minutes to respond.
So one of the things that petitioner made clear is that this is clearly a unique case. This is not the standard case. And we're appealing to the fact that this is not a standard case. This is a very unique situation that should stray. And that's why there are exceptions that we are asking to be made in this particular case, because it just doesn't, this particular punishment does not fit this particular scenario. And we want to be very clear that even giving a little bit of the history, this whole tax obligation came from another doctor who had been convicted and was convicted for the particular crime. It was not Dr. Melson that was related to, it was a Medicare fraud case involving another doctor in which he was working at that particular clinic for about 6 months, in which that particular doctor fired him and didn't give a reason as to why. We can guess maybe now because he was using Dr. Melson's medical license number fraudulently. But again, the tax liability was reduced from $955,000 to $126. And we talked about honesty. Dr. Melson is of the utmost integrity. And again, when he learned that this was a major issue, he was cooperative and did everything possible to cooperate with the authorities. So again, we definitely want to strongly ask that the probationary period be reduced and that the prohibition against him supervising physician's assistants also be lifted.
Okay, thank you. Ms. Lopez, your response.
Actually, I think the same comments were made previously, so I'll submit it if there's no questions.
Okay, does the panel, let me see, I think it's up to the panel whether they wish, oh no, it's, the ALJ shall offer the physician opportunity to address the panel. So, Mr. Ross, does your client wish to address the panel today?
Yes.
All right, doctor, I'm required to swear you in, so would you please stand and raise your right hand to be sworn, please? Do you solemnly swear or affirm that any testimony you shall give in this proceeding shall be the truth, the whole truth, nothing but the truth?
Yes, I do.
You be seated. And would you state your name for the record?
Enrico Antonio Melson.
Okay, go ahead, doctor.
Thank you. First of all, I'd like to say that I honor very much Deputy Attorney General for her character and professionalism and for her sincere belief in upholding the standards of the state of California. That having been said, I'm also saying that I am a victim of the bureaucratic conundra that sometimes are laden within the process of the state of California. I have not ever in my life evaded taxes. I will go to my grave stating that. I will not accept someone's telling me or telling others that I am dishonest. I am not. Thirdly, I have dedicated my life to serving this entire planet. If you have seen in my file, you will see the numerous titles and accolades that I have received because of that. Why would I come back here and be a dishonest tax evader? It makes no sense. I recognize the technicalities within the penal code. I understand that. But I also would like everyone here to know that if there is no change in the decision of the prior administrative law judge and that prior hearing that it is due to a technicality in interpretation and application of laws. It is not due to the particularity and individuality of this case, as far as I am concerned. I am not an attorney, but I am the person who has lived this. I've lived this all over the planet. I've written articles that have gone to presidents. I've consulted with prime ministers. I have gone years without income, and currently, in the last year and a half, I have been able to barely make $50,000. I have not had any income at all in the last 2 months, and that is due to not simply the issue on the physician assistant matter of supervision. It is also due to the fact that there is a systematic stigmata in place, as you all know, for anyone who has a criminal conviction. That stigmata has cost me now over 30 job offers in just the last 3 months. I have had offers where I have been about to jump on a plane to go and sign the contract, only to be called back and told, sorry, we've reconsidered. So even if I am to have to handle this technicality of restitution for taxes which I do not owe, unless the state of California is going to decide it's going to overrule the IRS. If the state of California decides that it's overruling the IRS and is going to assign me a tax obligation of $139,000, then I would like to have that in writing. And thus, this is also part of the process that we are dealing with. No matter that it is an issue not to be debated here by the tax board, it is nonetheless a truth. I stand here at risk of perjury and risk of incarceration or at risk of being tossed out of your courtroom, Your Honor, by telling everyone here it is BS when someone declares me dishonest, when someone declares me a willful tax evader. I also ask the question, how could I be a willful tax evader if my tax obligation is zero? I was a late filer. I had incompetent counsel. I accepted putting my name on what I was given as I have no choice other than to go back in that other door and go back in behind bars, and you can never go back out to New Zealand and continue your practice, and you've got all of your patients waiting for you. I've dealt with the fact that I've got to get back to work, curtail much of my career activities in international health in order to be here, roll up my sleeves, stay put, go to work 60 hours a week, make as much money as I can in allopathic medicine, and send it to the probation department and on to the franchise tax boards for taxes which I do not owe, and get this thing done. However, I am being systematically excluded from that. And that has to do with the hearings that has preceded and the judgment that has been proscribed. Now, I'm willing to go to Alaska. I've lived in Alaska, the coldest part of Alaska. I'm willing to practice medicine any place on this planet, and I am one of the few people who has demonstrated that over the last 30 plus years. I'm willing to practice medicine under any conditions, and I am one of the few people who has demonstrated that in wars, in disasters, in jungles, in places where most physicians will not go. I'm willing to do it in California. However, I am being precluded from that by virtue of the inconsistencies in this case. Because of all of that, I cannot even also apply for recertification with the American Board of Family Practice. I have been certified in multiple medical specialties. I am one of those highly credentialed doctors in this country and on this planet. And yet, because I did not continue to keep my American Board of Family Practice certification current because I have been also practicing in many other fields. When I come back here and I look to get my certification updated, I am precluded by this very same restriction status that says you are on probation. When I go to work in these community clinics, in these indigent care environments, now I'm told you can't get a Medicare provider number. You can't get a Medi-Cal number. The insurance companies don't want to pay for you because you're a criminal. You can't supervise physicians, assistants. You can supervise doctors. You can run the place. You can run the health department, which I have done in the past. But you can't supervise a physician's assistant, therefore we can't use you. We can't even use you to work as a physician's assistant very much, to have someone assigned for you because you're a doctor. We don't have a basis for someone co-signing for you. That's not transparency. So it is a catch-88 rather than a catch-22 that I find myself mired in this particular quandary and quagmire. I have no direct challenge to the intent and the letter of the law. However, I know the truth. My understanding and what I have upheld in terms of this state and this country all around this world is that there is a law and there is justice and there is truth. And there is also bureaucracy and technicality, which sometimes is not consistent with that law and with that truth. I happen to be one of those where if there is an application of Murphy's Law, it's likely going to find me. I recently had some money come to me that I could live on because I've only been able to make the bare bones minimum and hardly anything else. And that was a refund from the IRS. That refund came after I had to make more than 24 phone calls to the IRS because they lost my forms for over a year. And they realized that, oh, we thought you owed us, but we realized we owe you. I received a refund from the state of California for the year 2010. That refund was applied to this obligation with me on the telephone with the representative from the Franchise Tax Board. I checked on my payment records. It is not even located in my payment record within the county of the probation department as being credited towards the restitution. We know that there are multiple ways in which the difficulties of the bureaucratic system and its continuity and contiguity are substandard, sub-ideal. We understand this. I have to deal with this. I've dealt with it all my life. It is one of the issues that we're having to deal with in our legal team. The legal team, which, by the way, is working pro bono in my case. Sometimes I can barely make my $500 minimum monthly restitution payment because I don't have any income, and I got to pay for my daughter and child support and her education requirements. So again, this becomes the kind of issue where you examine it from multiple directions, and what you find is that either the guy is the biggest BS artist come along, or he's that handicapped guy with the cloud over his head that just seems to where trouble can find him. But the bureaucracy, in this case, doing its best, nonetheless, has not done things completely properly. I have never upheld myself as a completely responsible, on-time tax-paying citizen. I admitted to that. I consider that a character flaw. I have paid other bills late. However, I have never been an evader. And if so much of counsel's position is based on the innuendo, in the very least, that I am dishonest, then I rebut that completely. At the same time, as a matter of public policy, I recognize the necessity for protecting the public regarding others who are volitionally dishonest and deceptive in what they do. I recognize that. I'm in a quandary, though. I can't work so far because of these applications. I may not have a career as a clinician in medicine. I might have to have a career as a writer, because I have several books underway, but I might have to, either that or I have to dispense marijuana at these clinics to be paid as a doctor that way. Legally, yes. However, not completely consistent with my ethics, as I have explained in my argument. But if that seems to be the only way that I can work as a physician and support my family and make restitution and hopefully be able to make some money so that I can continue to pay for additional legal support, which is not going to be pro bono, so that I can address the issue as an appeal regarding taxes, which I do not owe, then I will do so. I recognize and I apologize for the young energy in my voice at this point. However, in all sincerity and in all humility, with respect to this issue, I feel I have let down the public. Yes, I've let down the public because I know what I do as a doctor. I know what I do as a humanitarian. I know what I do as a father, as a brother, as a son, as a community member, and as a global citizen. I know how many hundreds of people have themselves been let down directly because they get so impressed when they see me or they read about me. And then they look online and they see Beverly Hills doctor arrested for tax evasion. Or they look on the medical board and they see that record. So I know I let them down. I cannot go around explaining my case and all the intricacies to everyone all the time. I know I let down the patients who would otherwise be able to benefit from my care, who cannot benefit from my care because the facility cannot deploy me. I know I let down myself because this particular issue of being late, this particular issue of being in communication with the federal agencies, but not correspondingly, consistently, obligatorily in enough communication with the Franchise Tax Board, has led to the complications in this situation as well. I recognize that, and I accept responsibility for that. So yes, there is an issue of negligence here on my part. There is an issue of substandard irresponsibility. There is not an issue of accountability. My character, I accept 100% accountability. I accept 100% responsibility for what I do. Every word that I speak, every thought in my head, every action that I undertake, I accept 100% responsibility for that. This is how I've always lived my life. However, there is an issue. I would wonder if everyone understands or accepts and deems acceptable that a technicality in interpretation and an application results in a doctor with an otherwise stellar record of 31 years of practice of medicine all around this world is essentially ejected from the practice of medicine forthwith as a result of the application and these inconsistencies in the interpretation and these limiting technicalities. Therefore,
Doctor, I'm going to cut you off because I'm now hearing a repeat of the points you've made previously, and I want to give the panel members an opportunity to ask questions as well, all right?
thank you very much, sir.
All right, do panel members have questions? Of either Dr. Molson or of counsel? Yes, doctor.
Dr. Nelson, borrowing from the legal community, let's say that hypothetically you had the ability to get any kind of work that you wanted in medicine. What would that kind of work be? And tell us how you're qualified to practice that type of medicine.
Okay. The major areas are occupational medicine, primary care family practice, and urgent care medicine. These would be the areas in which I would and have been seeking employment. These areas are going to be most often they're community service, they're community-based. They're indigent care, at least in part, with respect to some of their populations. And I would, because of my probationary status right now, I'm currently limited to practice within the state of California. Under certain exceptions, I would be allowed to seek work outside of California. There are certain exceptions to that, which I have clarified with the probation department. I do have qualifications in many other areas, but these are the areas that would be most relevant, pertinent, within which I have been and will continue to seek employment. My needs would be to, my intent would be to work full-time and overtime, and certainly to be able to earn as much as I can to address the legal matter in terms of cost, and also in the event that there is no success on the appeal, to continue with this payment and retiring the restitution as fast as possible.
So when is the last time that you have been practicing in these disciplines?
Last time I actually saw a patient was 2 months ago. And I've been taken off the schedule since. The reason I've taken off the schedule is because of these limitations, or also the pending status of this hearing. There have been some others who have said, we'd love to have you, however, we're waiting the outcome of the board's decision.
Thank you.
Okay, other panelists, members have questions for Dr. Molson? Yes, sir. Yes, doctor.
Dr. Melson, I do understand about physician's assistant supervision. I work at a large academic institution with PA, physician assistants and all that. So tell me that if that condition is the only one lifted, what are your chances of having a decent employment where your obligations are met?
I'd say that they are less than 50-50, though they at least are real. In other words, I have had because my sample size has grown to 30 plus in the last 2-3 months of rejections. I cannot say that the restriction on physician's assistants supervision is the only or the primary factor. I have not been able to get Medicare provider certification, for example. That is irrelevant of supervision of physician's assistants. Medi-Cal provider certification, board certification, board recertification eligibility reestablished. These are independent of supervision of physician's assistants. The stigmata itself of being on probation, in some cases, my understanding is that that's no big deal. And yet the reality that I'm facing is that multiple insurance companies are exercising their own judgment as to whether they want to insure a doctor with this on his record or not. Again, having nothing to do with my knowledge in the practice of medicine, having nothing to do with the nature of the offense, just simply the fact that it is stated there. And so I just recently had been told here in Southern California. Sorry, I'm in Sacramento. I just drove up last night. I was just told that we did a review of our insurance providers. This is a medium-sized network of about a dozen facilities or 20 facilities in Southern California. They wanted me very, very vigorously to consider them. I had the interview process, everything went very well, but they said in our credentialing, we have to first poll our insurance providers. They had to call me back and said, sorry, Doc, we want to hire you, we'd love to have you, but you'd be providing services that we would not get reimbursed for simply because of that you have this status. So if we cannot be paid by the insurance companies, we cannot pay you. He said, at best, it looks like about 40% of our carriers would be okay. But do you want to come here and make 40% of what we were very happy to pay you otherwise? So this is part of the reality. I cannot quantify or differentiate, stratify amongst those multiple factors. They are all confluent at this time. Certainly, at the time when the administrative law judge decision was issued from the January hearing of this year, that decision did not factor in, and even that argument at that time by the state or my own counsel did not factor in some of these other issues. That has been empirical. That has been experiential. That has been what has happened as a result of the April issuance of the initial decision. From the beginning of April, when I first received the decision from the board, until the 26th of April, when the decision was supposed to go into effect, I was also working part-time and actively seeking employment. That's when things began to change immediately. I cannot say that if the issue of the physician assistant supervision is the only factor that is addressed, that I believe that I would be able to go out and be gainfully employed and make restitution and continue with my legal case review, simply because we're dealing with the insurance companies in that industry there, and there is great discretion by the providers as to whether they want to insure me or not. And also the fact, of course, that in the environments where I generally will work, these are patients who are covered under third party, particularly Medi-Cal, Medicare. And because I have this on my record, I cannot so far get work even in the federal system. I cannot get work in the corrections system. I cannot get work in the Indian Health Service, and yet I get recruited, so to speak, with over a dozen inquiries each day because of my credentials and my past record. It is indeed a quandary.
Okay, other panel members have questions? Nope?
Yes,
Okay,
Your Honor, actually, I
I'm
do.
sorry, go ahead.
For the, ma'am, your name from the Attorney General's office?
Cindy Lopez.
Cindy Lopez. Cindy, if this body was to consider alternatives, you expressed your dismay and your concern that this would set a precedent. Give me context by way of the number of cases that you're currently tracking that are similar to this.
I'm sorry.
Give me some examples. Give me context. So you said that this would establish a precedent.
All right, and let me clarify, because I realize in my papers I said exactly what I'm asking the panel to do, but I'm not sure if I made that clear today. As it stands now, the discipline is all the standard terms, and respondent is asking for you to lift the PA. And as I argued, he's not even getting any of the optional terms. If you keep the decision as it is now, that's fine. I mean, you have the choice, of course, of adding the optional conditions, but I would implore you not to lift this. Now, respondent makes a very compelling argument, I understand that, for lifting this. I mean, I have two reactions. just on a human level and then as a DAG. And unfortunately, sometimes those are inconsistent. It's very compelling. When I say that this will set a precedent, when these decisions come out, respondents, their attorneys, they talk about these things. I'm not sure necessarily if this is one of them. There are definitely some very high-profile cases that all of you are aware of that people talk about. And if you go and stray beyond these guidelines, my argument is that you're just making it a little bit harder for us when we go to the next case. So I'm not sure if that answered your question. You said
Well,
it put it into...
it starts to, and I appreciate your attempt. Statute, regulation, guideline, and understanding that there's less fungibility at the top of that pyramid and more fungibility at the bottom of it. And we're not here to,
Are we the bottom?
I would say, statute is, an act of
Right.
Congress or the legislature signed by the governor.
Right.
Regulation is a little more formal. That's what we're looking to do.
Right, and guidelines list.
Guidelines this. So
Correct.
I'd say more fungible, more flexible. And then in the context of one size fits all, understanding that the goal is a consistent application, and I respect your asserting that. There are some inconsistencies. You, as a argument, conveyed concern regarding honesty, but then also supported the applicant's sincerity. And so there's a little conflict there, and I'm looking for a nexus for addressing how someone's supposed to make restitution and how someone gets out of the quote-unquote system ever if they are then put in that context. In essence, there's a box, check the box. Ban the box? No, check the box. So if you look at it and say, at what step in the process is there ever a way to break out of the process? If you look at it one size fits all, and you look at a consistent application, then we're blind to it.
Correct. Okay. I'm not saying there's one size fits all. The reason why there's model guidelines is because one size does not fit all. Clearly, every case is different. The model guidelines are there for a beginning, and you can either stray from them by going above and beyond because the case is so aggravated, or you can stray from them and not apply all the conditions if the case, and maybe you think this case, there's mitigation. So there is no one size fits all. Again, I've done a gazillion of these cases, and there's not one single case that has the exact same facts as another one. Does that?
I appreciate that. I guess it's, we live in a world of unintended consequences. And so every time there's an action taken, sometimes there's an equal and opposite reaction. And so that's some of what we're trying to listen for, or what I'm trying to listen for here. By the way, listen, I appreciate you answering the question. Thank you.
I have a question with respect to finding 7 in the proposed decision relating to the tax obligations for the 2005 federal tax return. What was the evidence presented that, or upon which the ALJ found an obligation of $126.78 to the IRS and no obligation to the Franchise Tax Board?
I believe that was from the, when we do these conviction cases, we submit certified documents of the criminal complaint and the minute order when they plea. So I don't have the plea in front of me. I believe that was from the plea agreement, and I'm not positive. To be honest, though, I don't remember ever talking about the federal part of it being 0. I do remember the $126 because it was so off from the $139,000 that they originally found. But I believe that was from the plea agreement.
Okay, well, you anticipated my next question. The panel members may be confused, as I certainly was, based on this finding in paragraph 7 and how that squares with this restitution obligation of the Franchise Tax Board. It just, honestly, it just doesn't make a lot of sense to me, just reading the proposed decision.
I understand that, and again, and I don't want to not answer your question, but when we have these cases, we present the ALJ with the certified court documents. That's what was agreed to. Again, if counsel had incompetent counsel, and I hear that, gosh, all the time, if he had incompetent counsel, that's something he has to deal with in his criminal appeal. And I don't mean to sound disrespectful, but that really is kind of irrelevant to our case. I don't know why there is such a discrepancy between this restitution of $139,000 and then this tax liability for $126,000. That did not come out in our hearing.
Okay. Any other panel members have questions for counsel or Dr. Molson? Nope. I think the panel is going to, I know the panel is going to meet in executive session now and decide this matter. And Doctor, do you want to set a time to begin the next, because I think that was supposed to start at 10:15. That's not going to happen, so.
It'll start as soon as we finish our decision.
Okay, all right.
Okay, so they can just wait outside. So we'll move now into closed session.
Thank you.
Board of California, we're now back in open session, and I'd like to turn over the session to Judge Engelman.
Okay, Jody, we're ready down there? Okay, we're on the record in the matter of the petition, I'm getting a little echo here, aren't I? For penalty relief of William Y. Moores, MD, Physicians and Surgeons, certificate number G28505, case number 26-2011-217327. My name is Carl Engelman, Administrative Law Judge assigned to hear this matter. We're convened in Sacramento, California on the morning of July 18, 2013. And I would like the panel members, even though you did so in the earlier matter, and during roll call to identify yourselves for the record, please.
Jerry Shipsky.
Dave Ganadev.
Denise Pines.
Phil Tagami.
Thank you. And may I have the appearance from the representative from the Department of Justice, Office of the Attorney General?
Good morning. I'm Deputy Attorney General Esther Law, appearing on behalf of the state of California.
Okay, thank you. Dr. Morse, are you here?
He's not here. He made no submission.
Let's go off the record. You obviously, you know him on site or by,
Yes, I would recognize him.
have you seen him this morning?
Not seen him, no.
Okay.
I also, as far as I know, I didn't receive a written argument from him.
I didn't see one in the file. Well, that's a good question. That's a good question. The board has non-adopted the proposed decision before rendering its own decision. The board has to offer oral or written argument, and well, I guess by statute, the board must offer both the opportunity for written argument and oral argument. I think the medical board. Do you remember?
I don't know.
This is the place for the presentation of such argument. There is, at least in my view, there seems to be a legal issue that the panel probably has to grapple with. I guess we should, what's your view on whether we should proceed with oral argument in the absence of Dr. Morris, Ms. Locke?
I don't know if it's required. I don't think he's asked for one, and we've given him notice that there would be one, though. Again, I'm actually admitted a written argument, and I'm happy to stand by that, but I'm also happy to answer any questions, or I've written out a spiel to present today, and I'm prepared to give that as well, too.
Okay, all right, let's go back on the record. Okay, this matter was noticed for 10:15 this morning. It is now 10:30 a.m. There's not been any appearance by Dr. Moores, nor by anyone on behalf. Ms. Laws indicated she is prepared to augment her written argument, this matter, with an oral presentation. So in the absence of Mr. Moores, Ms. Law, proceed.
Thank you. This was a petition for termination of probation case, and so the burden was and is on Dr. Moores to demonstrate that he's entitled to termination of probation. And the main issue in this case is whether Dr. Moores, whose probation was told for non-practice, has been engaged in the practice of medicine to warrant termination of his probation. And I'd like to just briefly go over the factual and procedural background, because I think it bears directly on the issue of whether the board properly told his probation. In January of 2001, an accusation was filed against Dr. Moores, who specialized in cardiothoracic surgery. And the accusation alleged 9 causes for discipline, including gross negligence, repeated acts of negligence, and/or incompetence with respect to Dr. Moores' care and treatment of 8 patients. Dr. Moores eventually entered into a stipulated settlement where his license was revoked, but the revocation was stayed, and he was placed on a probation for 5 years. And that stipulated settlement was adopted as a decision by the board and became effective in November of 2001. And one of the conditions of the stipulated settlement and the decision was Condition 21, which provided that if Dr. Moores did not engage in the practice of medicine as defined under Business and Professions Code sections 2051 and 2052 for a period exceeding 30 days, his probation would be tolled. Now, 3 days after that effective date of decision, Dr. Moores met with his probation officer, Ms. Katerina Lee, and he informed her at that time that he was currently not practicing medicine. And he also told her that he had no plans to practice medicine involving direct patient contact, and that he instead wanted to teach and do research. And Dr. Moores followed up that meeting that same day with a letter to Ms. Lee, and he stated, quote, "For the immediate present, I will declare I am not going to be engaged in practicing medicine," unquote. 2 months later, in January of 2002, Dr. Moores wrote to his probation inspector and stated that his practice situation had not changed since his November 5th, 2001 letter. That is, he was still not practicing medicine. And a year after that, in February of 2003, Dr. Moores told his probation inspector again that he was still not practicing medicine and was instead working as a consultant in cardiovascular surgery and providing expert testimony in malpractice actions in Wisconsin. And all of these facts are undisputed. And because Dr. Moores, by his own admissions, was not practicing medicine and had not been practicing medicine since the beginning of his probation, the board told his probation consistent with Condition 21 of the stipulated settlement and decision. And it was not until the board told his probation that Dr. Moores claimed for the very first time, and in direct contradiction of all his prior statements to the board, that he had been practicing medicine, that he had been practicing general medicine all along since 1998. But Dr. Moores admits that he does not keep a log of any patients that he sees. He does not maintain records for any patients. He doesn't document any advice that he provides to patients. So there's no corroborating evidence to support his claim that he sees or treats patients. Now, at the hearing before Judge Astle, Dr. Moores testified that his practice basically consists of giving advice about nutrition and healthy living. And he referred to an article he had written entitled "Food Rules for Healthy Living," as containing the core of the advice that he gives to his patients. And that article was submitted into evidence as Exhibit 10. And he characterized the advice that he gives in these articles and to his patients as preventative medicine, and therefore falling under the definition of practicing medicine under Code Sections 2051 and 2052. But if you look at his article carefully, what Dr. Morris is doing is he's simply providing nutritional advice that parrots advice that's been provided by Michael Pollan and other non-physicians. In fact, if you turn at the first page of his article, he states that his food rules boils down to the following 8-word rule, which is eat real food, not too much, mostly plants. And if you've read any of Michael Pollan's books, you know that comes directly from Michael Pollan's book. And Dr. Morris acknowledges that in his article, that this 8-word food law comes directly from Michael Pollan, and that his article basically just elaborates on this basic food law. And Dr. Morris has written a second article called Food Rules for Bohemians, which is Exhibit 11, and that article also is parroting Michael Pollan. And again, in that article, Dr. Morris says that he pleads guilty to being a word thief and using Michael Pollan's writings as my basis for Bohemian food rules. So again, if you look at his advice, it's no different than advice provided by Michael Pollan and other non-physicians. And I just want to quickly go over some of the additional rules that is based on the basic food rule to eat real food, not too much, mostly plants, to demonstrate the generic aspect of this advice. Rule 1 was to avoid or minimize processed industrial foods. Rule 2 is to avoid or minimize foods containing white flour and refined sugar. Rule 3 is size matters, control portion size. Rule 4, limit your consumption of bad fat. Rule 5, non-industrial animal products containing cholesterol and naturally occurring fats are not bad foods, enjoy them. Rule 6 is take omega-3 fatty acid supplements. And Rule 7 is pay more, eat less. And again, all of these rules come from Michael Pollan and other non-physicians. I'd like to go over Business and Professions Code Sections 2051 and 2052, because those are the relevant statutes. Because, again, under his stipulated settlement and the decision, he has to be practicing medicine as defined under these two statutes. And it is the Attorney General's position that Dr. Morris is giving of generic nutritional advice does not fall under either of these two statutes. Section 2051 provides, quote, the physician's and surgeon's certificate authorizes the holder to use drugs or devices in or upon human beings and to sever or penetrate the tissues of human beings and to use any and all other methods in the treatment of diseases, injuries, deformities, and other physical and mental conditions. And it's clear that Dr. Morris is not using any drugs or devices. He's not severing or penetrating the tissues of anyone. And he's not using any other methods to treat any diseases, injuries, deformities, or physical and mental conditions. He's simply giving generic nutritional advice. Section 2052 concerns the unauthorized practice of medicine, and it provides, among other things, that any person who practices any system or mode of treating the sick or afflicted in this state, or who diagnoses, treats, operates for, or prescribes for any ailment, blemish, deformity, disease, disfigurement, disorder, injury, or other physical or mental condition of any person is guilty of a public offense. And again, if you go through the statute and you compare it to what Dr. Morris does, He's not treating the sick or the afflicted. He's not diagnosing anyone. He's not treating anyone. He's not operating for anyone. He's not prescribing for any ailment, blemish, deformity, disease, disfigurement, disorder, injury, or other physical or mental condition. Again, he's simply giving generic nutritional advice that's been given by many, many non-physicians. And I do want to point out that from a practical perspective, if the giving of generic nutritional advice is to be considered the practice of medicine, then the practice requirement that's a condition in the settlement agreements and the stipulated settlements would be rendered meaningless, because any physician could say that I give nutritional advice. I tell people not to eat high foods with white flour or sugar, and that's considered to be the practice of medicine. And if anyone can do that, there's no purpose of having a practice requirement during probation. Now, the ALJ found that the nutritional advice that Dr. Morris gives does constitute the practice of medicine, but she relied, and she improperly relied, on the testimony of Dr. Gardner to make this finding. And Dr. Gardner's opined that Dr. Morris's activities is considered to be preventative medicine and falls within the scope of sections 2051 and 2052. But Dr. Gardner is not competent to render an opinion on the scope of sections 2051 and 2052. That's calling for a legal conclusion, and an expert is not authorized to testify as to legal conclusions in the guise of expert opinions. So for that reason, her reliance on Dr. Gardner was improper. And additionally, Dr. Gardner is not licensed to practice in California. He's never been licensed to practice in California and has never practiced in California. And his testimony indicates that he really has no knowledge of the standard of practice in California when treating a patient, because he testified that the standard of practice does not require a physical examination before making a diagnosis, that doesn't require taking a history, and that there's no requirement that a doctor maintain records of patients that he treats. So I think Dr. Gardner's opinion as an expert on the practice of medicine is highly suspect. But Dr. Gardner did state that a medical license is not required to provide the nutritional advice contained in Dr. Morris's articles. And if that's true, if a medical license is not required to provide that advice, then I would submit that advice does not constitute, the advice in and of itself, without anything more, does not constitute the practice of medicine. The ALJ's proposed decision also references the declaration of Dr. Richard Weiskopf, but that declaration was never admitted into evidence, and so the ALJ's reliance on that declaration was also improper. And I also want to address the issue of rehabilitation, since the board specifically asked for argument on the issue of whether petitioner has provided sufficient evidence of rehabilitation to warrant termination of probation. And the answer to that question is no, he has not. And the ALJ erred in finding that he had, because the ALJ applied the wrong legal standard, in that she found that Dr. Morris had demonstrated good cause when, in fact, the burden of proof of showing rehabilitation is clear and convincing evidence. And the ALJ found that Dr. Morris was rehabilitated and safe to practice medicine based solely on Dr. Morris's testimony that he had no intention of practicing cardiology or cardiac surgery in the future, and that he had demonstrated that he was safe to give advice on diet and lifestyles. But Dr. Morris's testimony that he doesn't intend to practice cardiology or cardiac surgery, that's not sufficient evidence. That's not clear and convincing evidence of rehabilitation. With an unrestricted license, there's nothing to prevent Dr. Morris from returning to the practice of cardiology. And Dr. Morris has not produced any evidence that he's safe to practice as a cardiologist or cardiothoracic surgeon. You know, he was disciplined for numerous instances of gross negligence, and he's required to demonstrate, the burden's on him to demonstrate that he is safe to practice cardiology, that he's been rehabilitated, and he submitted no evidence to do so. So in conclusion, it's the Attorney General's position that Dr. Morse is giving of nutritional advice without anything more is not the practice of medicine under Business and Professions Code Sections 2051 and 2052, and that his probation was properly told. Dr. Morse has not met his burden of showing rehabilitation, and that he is safe to practice without restriction. Accordingly, the Attorney General recommends that the board enter a decision denying Dr. Morse's petition for penalty relief.
Thank you. Questions by panel members? Ms. Law. Dr. Law.
Yes, you made a statement about the practice of medicine having to involve the physical examination of patients. Is that correct?
No, I said the standard of practice when treating a patient or giving a diagnosis might require a physical examination. It was Dr. Gardner's testimony that the standard of practice didn't require a physical examination when making a diagnosis.
You know, one of the things that I have a lot of problems with is people that do utilization review, physicians that do utilization review.
I can't hear you.
I apologize. One of the problems that I have with this definition is that people that practice utilization review, who are physicians working for, in general, are insurance companies or third-party people that screen for insurance companies, we believe that, or at least I believe, they practice medicine.
And the board may accept those types of practices as practicing medicine for probation purposes. But
For
under
what?
this- For probation purposes, when a physician is under probation, is that the context that you're looking
Well,
at this?
these people do it all the time. That is their profession.
Right.
They're utilization review doctors that never see or touch a patient. You call them with something and they give you a ruling, and they're practicing medicine.
They may be, but I don't think they're practicing medicine under these two code sections.
Well, I mean, but it's still the practice of medicine, isn't it?
Right, but the probationary condition specifically referenced these two sections.
Okay, all right.
I mean,
I
it was
can live with
limited to
that.
those definitions.
So I just find it very interesting that the administrative law judge found that the evidence was compelling to terminate his probation. I mean, isn't that interesting that we present an expert from the medical board side? They present one expert and a document, and the administrative law judge concludes that his probation should be terminated.
Well, I don't think it was correct for her to accept expert testimony at all. There was no need for expert testimony, and it was improper to receive expert testimony on the issue of whether
Well, did we have a DAG at that hearing?
we did. I was the DAG at the hearing.
Well, I mean, your arguments obviously weren't very compelling to the administrative law judge,
Obviously not.
which is the problem that I have.
I think she was wrong.
I think many of us that reviewed this did not feel that his probation should be terminated, yet the administrative law judge decided that it was based on what she heard at hearing. And I think that's what brought this to today's meeting.
Right. I think what Dr. Morse's expert, what he argued, or what his position is, if advice comes from a doctor, that's the practice of medicine. So he was saying, you know, if the doctor is giving nutritional advice, that's the practice of medicine because a doctor is giving that advice.
The only thing that I'm conflicted with is the fact that they were able to convince the administrative law judge. Yeah.
That's why.
Anyway, all right. Any other questions?
Doctor, you had a question?
Yeah, I mean, now I can see what the sections you quoted, because utilization review is practice of medicine. Medical information technology is practice of medicine. If you're an administrator in a hospital where you don't touch a patient, that's still a practice of medicine. We take that all for granted. So if we restrict the practice of medicine to only examining patients, that really concerns me. But now you mentioned that that was in his probation, those two sections. Now I understand that.
Okay.
That's what, but otherwise, what he was doing, you could quasi call it a practice of medicine, even though he might be a danger to the community to do cardiology, which he hasn't practiced for a long time. So that's why that was our concern. So I'm still, like Dr. Lowe, somewhat puzzled and surprised how we, the medical board, lost it out at the ALJ hearing on this issue, where the person hasn't done anything with a patient, and it doesn't even say that it's lifted with some kind of a significantly restricted license. It just says it just lifted. So that means he can have full license. That's why I'm just puzzled.
Any other questions for Ms. Law from panel members? No? Okay. The panel will meet in executive session, decide the matter, and then issue a decision to be served upon the parties. Thank you, Ms. Law.
Thank you.
Off the record.
And welcome to our guests, members of the public, and our panel members, our board members from Panel A. As I said, we're delighted to see you. And we're going, yes, we're going to call the afternoon session of the Medical Board of California into order. Before we start, I'd like to ask everyone to turn cell phones to silent and make sure BlackBerries and anything that might ring is off the table so we can avoid feedback. Members will be using laptops or iPads or other tablets to access board materials that are in electronic format as we make a lurching move toward a fully digital environment. This is an official business meeting of the Medical Board of California, and I will attempt to conduct this in an orderly fashion. We do have a designated time for public comment on the agenda for each agenda item, and a designated time for items not on the agenda. And we welcome public comment on all of the above. And I will call for public comment prior to the board taking action on any item. If I forget, I know one of my colleagues, my hardy attorney over here, will give me a poke in the ribs. But please, if you desire to speak, please raise your hand, and I will recognize you. And I would ask that any speakers please fill out a speaker slip, either ideally before we get to the agenda item you'd like to speak on, or afterwards, so we have a complete record of the proceedings and can present a full and accurate record to the public when we post the proceedings of the board on our website. I'm going to ask Ms. Lisa Toof, who's sitting at the front table, to collect any speaker slips. And as I said, I will do my best to call on everyone and anyone who wishes to speak. We are actually delighted at the level of interest in the proceedings of the board. And as we've noticed from our last couple of meetings, we have more and more interest from members of the public to speak on agenda items. And so we're going to start off with limiting speakers to 3 minutes. We will have a little traffic light, red, yellow, and green, that you'll be able to see. And I would ask that you limit comments to 3 minutes. If your comments have been essentially given by the previous speaker, we'd be happy to hear your agreement, but don't feel obligated to repeat comments that have been made. Our hope is to end at 5:30 today. And we will take, we're going to take one agenda item out of order. We may lose a board member tomorrow because of pressing business. And so we are going to have at the end of today's agenda, we're going to have the board elections for the next business year for the Medical Board of California. And we'll do that before we adjourn at the end of the day today. Ms. Toof, could you please take the roll call?
Absolutely. Dr. Bishop?
Here.
Dr. Diego?
Here.
Dr. Gonadev?
Here.
Dr. Lowe?
Here.
Ms. Pines? Here. Dr. Solmonson?
Here.
Ms. Shipsky? Mr. Serrano Sewell? Here. Mr. Tagami? Here. Ms. Yaroslavsky? Dr. Yip? And Dr. Levine?
Here.
Thank you.
Great. We do have a quorum. We actually have 100% attendance. And before we actually go to public comments on items not on the agenda, I want to recognize guests we have with us today. It's always a pleasure for us to have representatives from the legislature, from the administration with us, and I do want to be sure that everyone recognizes their commitment to attend the board meetings. And today we have with us our newly appointed liaison from the Department of Consumer Affairs, the liaison for Board and Bureau Affairs, Ms. Christine Lally, and her executive assistant, Corinne Fishman. We have with us Taryn Smith from, there you are, Taryn Smith from the Office of Senate Research, which supports the Senate Rules Committee, G.V. Ayers, who's a consultant to Senate Business and Professions, and Karen Fisher, who's with us today, who's the Executive Director of the Dental Board of California. So welcome, delighted to have you. And we have a congratulations and a very bittersweet announcement. Our congratulations to Jerry Shipsky, who learned yesterday, as we did, that she was chosen by the White House as a champion of change for open government. She's one of 7 individuals across the country selected, and she will be honored at a ceremony next week at the White House. And do you get to spend the night in the Lincoln bedroom?
I will be open about it if I do it.
Okay, open government, right. And it saddens me deeply to share with everyone that this will be Dr. Reginald Lowe's last meeting of the Medical Board of California. He has served 8 years, 2 terms as a board member, and I don't have to tell anyone in this room how significant his contributions to this board have been, and we will at a later time enumerate his contributions and leadership role he has played, but know that we will miss you, and we're really sorry to see you go. Dr. Lowe has chaired the Enforcement Committee and is, I think, largely responsible for the tremendous work done over the last year and a half on really beefing up our expert reviewer program and implementing a training program we can all be proud of. So on behalf of all of us, thank you for your contributions. And I will move to agenda item 2, which is public comment on items not on the agenda. I don't have any slips. Is there anyone who wishes to make a comment? Okay, then we'll move on to agenda item 3, which is approval of the board minutes from the June 4th, 2013 minutes. Are there any additions or corrections to the minutes on the part of board members? I'm sorry?
Motion to approve.
Great. Any comments? Any other comments? Any comments from members of the public on agenda item 3, approval of the minutes? I'm sorry, I'm sorry, my error. This is the June 4th?
Yes, June 4th.
So this isn't, okay, great. Forget that. Okay, so we'll move on to agenda item 4, and I am really thrilled. Oh, sorry, right. All in favor?
Aye.
Opposed? Abstentions? Okay, great. I'm going to move to Agenda Item 4, which is a presentation on Covered California. And I'm really delighted to introduce our speaker today, Dr. Jeff Rideout, who's been a friend and colleague of mine for many years. Jeff is currently the Senior Medical Advisor for Covered California, State of California's health insurance exchange, which will be open for business on October 1, 2013. Dr. Rideout is responsible for clinical quality network management, delivery system reform, and clinical and network analytics related to the estimated, eventually, 3 to 4 million eligible Californians who will have the opportunity to get insurance coverage through the exchange. And as I said, the exchange opens for business October 1, 2013, and Covered California has been recognized and called out by many, including the president, for being the first state and the state that is furthest along in terms of being ready for the October 1 opening date. Dr. Rideout has a distinguished history. He served in a number of corporate leadership roles, including Senior Vice President and Chief Medical Officer for TriZetto Group. He was the global leader of the healthcare division for Cisco Systems Internet Business Solutions Group. That's a long name. And Cisco's Chief Medical Officer. He's been Chief Medical Officer and Senior Vice President for Blue Shield of California and Head of Quality Management for Blue Cross WellPoint. He serves on a number of industry boards, including PBGH, Pacific Business Group on Health, and the Integrated Healthcare Association. He's a board-certified internist, trained here at UCSF, and as a fellow of the American College of Physicians. And I assume a licensee of the Medical Board of California, right? Please come up to the microphone, Dr. Rideout.
Thank you very much. It's a little bit awkward. I don't want to ignore people behind me, but I guess this is what we'll do. First of all, thank you very much to the members of the board and the public for inviting me and Covered California to present. One of the biggest challenges for us is education and helping everybody learn as we learn what's about to come and what's in it for everybody. And by way of a question, Dr. Bishop, are you the same Michael Bishop that are on our Plan Advisory Committee Council?
No.
Okay.
Different Michael Bishop.
And I asked that because we've had several meetings, but that Dr. Bishop actually participates typically by phone. So I just wanted to make sure, because I thought maybe you had an insider here. I want to make
Best
sure.
of my knowledge, I haven't had an amnestic fugue lately.
Okay, good. All right. So what I was going to do is spend a little bit of time. This is a standard presentation that was developed for a number of community town halls that we've been doing across the state. So the content is the same as community leaders, individuals are seeing. I don't want to necessarily dwell on the points of the slides if there are other questions, so I may breeze through some of this pretty quickly. And by design, this is more about the setting up of the exchange, the challenges of identifying people that are eligible for the exchange, the advantages from a income subsidy point of view for many Californians, and also where we are in terms of enrollment. And those are the big things that we face right now. October 1 is coming very, very quickly. As the senior medical advisor, I'm very, very interested in a lot of things that are also being developed now around network management, clinical quality. Those are things that we will be addressing much more aggressively as we go along. But right now, the main goal is to get people aware of what the exchange is there for and get them enrolled if they're eligible. So.
And Jeff, I am going to ask you, if you can, this will be the first question, which is to cover in your remarks, the implications for physicians and the role physicians can play in assisting their patients understand what's going on, because we do have an opportunity to use our communication channels to assist in this. So
Absolutely, and by first order way of answering that question, there has been, and I'll go into some detail, a very large community grant program for community awareness grants, but we are in the middle of a clinician and provider grant program as well. So organizations like NEPO and other physician organizations are in the process of deciding whether they would like to apply for those grants, so that part of the physician education exercise goes through known channels like medical societies and existing organizations. But I'll go into that in a little bit of detail.
Also, for the board members, are there other topics that you'd like me to emphasize as I go through this? That might be a good way to start, because there's a lot of information, and some of it may or may not be of interest.
Any information that you can provide us as to the stakeholders, the physician as well as the patient community, as to how to find, look up opportunities, what kinds of things that they should be looking for within their own practice that is going to be now covered by, where are the holes and where's the coverage going to be?
Jeff, actually, there is a lot of confusion among physicians how they're going to get paid. And a lot of people came to me, not as medical board member, as the past president of California Medical Association, how is it going? Each insurance company is sending them different ways as an addendum to previous contract, from someone trying to pay at Medi-Cal rates to someone trying to pay at Medicare rates or slightly above. So is there any way you are taking an approach to really standardize it or do something with it so that physicians are not left in hole and may not sign up, even though the insurers are telling all the people that, yeah, they have all these people signed up, but the clause for the exchange is not there in a lot of contracts yet. So if you can explain.
Yeah, and maybe I'll take that one head on, because I think it's going to be an important and ongoing dialogue or debate. First of all, what people should understand, the exchange is organizing health plans and their physician and other provider delivery systems to supply insurance to those that are eligible, and for subsidies, and those that would like to buy coverage through the exchange. We are not dictating or telling people how to create those networks or the rates that go into that. And right now, the network configurations are still, they're with the regulators, DMHC primarily, but also CDI. But the actual configuration of the networks is still not something that's publicly available. I've obviously seen them, but I will say that the network configurations, in some cases, are very different and specific to covered California. And we do have participants that have historically been providing insurance to Medi-Cal recipients. We have others that are exclusively commercial. We have some that are exclusively commercial HMO. So there's a wide range of participants. Some are new completely to the individual market. So a long way of saying it depends, and unfortunately that's a frustration, a very legitimate frustration for physicians. We've been in dialogue with CMA. I have personally several times about simply who's in, do they know they're in, under what conditions do health plans think they're in, and what are they getting paid. And so our role is really to facilitate a better dialogue between parties. I was actually shocked in meetings with some specialty societies that some physicians are having a hard time finding out whether they're in or not. So it's a long way of saying we're working on it, and I'm trying to push the dialogue so it's not assumed that people are in simply because they have maybe an all-product clause in their contract. So, sorry, that's going to, yes?
I have apologized, but what I really wanted to ask you before, and I couldn't find it, but now I found it, is that currently, is there, oh, well, not currently, but there are patients that are covered under certain Medi-Cal and certain county programs. And for continuity of care, the question will be, is Covered California going to be creating any kind of a bridge program so that if you're seeing a county doctor currently on Medi-Cal for years, and now you've earned enough to move out of Medi-Cal, can you stay with your county doc even though your insurance changes? So if you could think about that, if there's
Sure.
down the road. But the issue is that, so that there's some kind of continuity of care as well, and how patients are going to be notified of that, as well as those public officials that are.
Absolutely, and one of the biggest challenges is the transition of individuals between Medi-Cal eligibility and exchange eligibility, and not only how to ensure continuity of care in their physician and clinician relationships, but also financial continuity as well. So it's a very, very big challenge. We are working very closely with the Department of Healthcare Services, and the chair of the Exchange Board is actually Diana Dooley, so that creates some continuity right there. Obviously, we're not talking to Diana about every issue that pops up, but there is a strong connection between the organizations. Whether we can guarantee that anybody can stay with a particular physician, that's really up to the networks that not only are available, but the networks that people choose, because a lot of the choice for individuals in the exchange may actually be what they think they can afford and what type of benefit plan that they're looking for. So, and I'm fine, because I think your questions are probably going to be more beneficial to you than the very beautiful slides that we've prepared. But these are pretty self-explanatory. I'm not going to read them to you, but there's lots of reasons why people don't have insurance. And as I think we all know, the Affordable Care Act actually was a very big lift to try to address many of that. And I think it's fair to say, without getting political about this, depending on what you value and what you think is a priority, that will dictate a series of decisions that drive how these things roll out. And to the extent that coverage is important for all individuals, as I believe, and I'll say that as a person personally, there are a series of implications to that that are starting to play out as we see now with the Affordable Care Act as it gets implemented. Whether it's the best way to get there, the only way to get there, we can have that debate. But I think what is rolling out not only here but in Oregon and Washington and New York State are the consequences of a commitment to providing insurance for most, if not all, citizens. These are some of the things that came before the implementation of the exchanges. Also, probably worth noting, there is now a bit of a trend. We announced our both plan selection and our rates in May, and as many of you probably saw, New York State announced theirs just yesterday, and there was a front page New York Times article with some pretty stunning comparisons of the cost and the affordability. And we are seeing, it's tricky to make these comparisons, but we are seeing those kinds of affordable rates in the state of California as well. But I think more important, and what I'd like to leave folks with as a physician, is ensuring that individuals, both patients and consumers, have some protection against the financial liability that comes with the extraordinary advances in costs of care these days. And so a lot of what the exchange here has tried to do is not just be a passive conduit for buying insurance, but also think about proactively driving certain things that are good for consumers. And one of those is standardized benefits. Being a former insurance executive, at one point, one of the plans I worked for had 1,700 different versions of a PPO. So imagine trying to manage that, and that was no exaggeration. Every variation that any employer might want was potentially available. What's really important with the exchange, and actually nationally, is the benefit designs are standardized and are comprehensive. So there is no worry that you won't have pharmacy coverage for essential benefits. There's no worry that you won't have preventive health coverage for free. So a lot of that goes to what you get, and that's what makes some of these comparisons difficult, because what you could get previously before the ACA was maybe not a lot, but it would be bare bones coverage or emergency coverage. The other thing that goes with that is financial protection. So the importance of making sure that those benefit plans are clear to consumers that may never have had insurance before, but also their financial liability, both for what they choose to pay as a copay or deductible, and their overall liability is capped and related to their income, so that people are not caught out by a unforeseen catastrophic healthcare event. The other thing on this, the rates are not based on your health status. That'll weave into the whole discussion, of course, but the implication of that is that we move toward a system more of community rating, where the implication for the exchange and for any exchange is it is very, very important to get the healthy that are now required to have insurance into the insurance pool, because that is how insurance works. We fund the costs of necessary care for those that are sick and elderly with the good health of those that are younger, and making sure that's a level playing field by standardizing the benefits and the out-of-pocket costs as part of the equation. There are some requirements, as you know. I think one of the things that I would encourage people to watch is where medium to small group employers, what they decide to do. Now, there's a lot of information about small group employers, the delay in that requirement. I think when people start understanding the affordability of buying insurance through the exchange, there will be a question about whether it's better to continue to provide coverage through the employer or have employees get subsidized to buy it through the exchange. So that's another point. This gives you just a listing of the essential health benefits, and I think most of us as consumers and most of us that are clinicians think this is all pretty good and wholesome stuff. It is important to understand that not every insurance benefit plan that's available now to individuals has all of this. but it will beginning in 2014. So who are we? I'm going to keep rolling. As Sharon mentioned, we are the first legislated health exchange. Obviously, Massachusetts and Utah preceded this, but this was a kind of early in, let's get on with it and be proactive from the state of California. We are one of 17 exchanges, but we will be the largest in terms of serving the population. One thing to note, other than the state of New York, many of the exchanges are in smaller population states, so what that means is for those that are needing insurance, because it's now a mandate, they'll have to get their insurance through the federal exchange. So more than half the population, because states have chosen not to establish their own exchange, will need to look for options on the federal exchange, even if they live, in a state that could have chosen to put an exchange up. We are .com, and by that we mean we are a special organization that's a part of the state, and it is state-run, but we have an independent board. That's probably the most important thing to understand. 5-member board, some very, very good people, including Diana Dooley that I mentioned. And we are working with a number of name-brand health insurance organizations, but many that are new to the individual market. So that's another kind of trend that we're seeing in certainly Massachusetts and New York, is that this has created room for traditional participants to grow their market share, but it's also created room for new entrants as well. And one of the things that was curious, that none of the national health plans chose to participate in the California Exchange, but 85% of the individuals that get individual insurance in California are covered by Kaiser, Blue Cross, and Blue Shield, and all 3 of those are participating. Pretty important point that premiums are based on income. So the subsidy that you may have heard about, it's actually a tax credit. So the way I look at it, it is working against reductions in future taxes as opposed to new taxes on other folks. But it is based on income, and that's different. So a policy is based on, in a large part, your ability to pay, and I'll go through that as well. The co-pays design, there are differences in the amount of co-pays and the amount of cost sharing, but they're all designed to encourage preventive care and minimize out-of-pocket expense, and we'll show you what that means for people at different income levels. And some plans are actually zero deductible. All preventive care is free, and that's part of the national essential benefits, and minimizing the out-of-pocket maximums so that individuals are not saddled with the financial burden of getting necessary care. These are the plans, a lot of well-known names, and probably some ones that people know of but are new to this market. Interesting that some of them are seeing this as their opportunity to enter an individual market. I should point out the regions for the exchange. There are 19 of them in California that follow from north to south, so a lower number region is Northern California, region 19 is San Diego, but they don't follow strict county geographic lines. So one of the challenges is there are 2 regions in LA, 15 and 16, but they don't follow sort of normal geographic or freeway boundaries. So part of our challenge is that we need to get coverage for all these areas, and we do have statewide coverage, which is great, but they don't match anything perfectly. So Ventura, I'll use as an example, they are in one of the regions, but they serve only part of that region. So some plans are serving primarily urban areas, other plans are serving parts of regions where they have physician and provider networks available. This gives you an idea of the coverage within some of the urban areas. You can look at that, but a good mix of traditional Medi-Cal providers, commercial plans, more ethnically focused plans. Here's kind of where the rubber hits the road, and this is what we've released publicly so you can get an idea. I'll just go through one line, and I'll use Sacramento as an example. First of all, Sacramento's Region 3, there are about 126,000 subsidy-eligible individuals in Sacramento, so not the biggest area. You go down to Los Angeles, and you can see where the enrollment really may come from. But if you look at, there are 4 metal tiers. You may have heard that term. So bronze, silver, gold, and platinum. And that really designates not the benefits, but the degree of cost sharing. So a bronze plan minimizes cost sharing. So that might be something that a young, healthy immortal that doesn't think he or she needs insurance would choose, whereas a silver or platinum plan might provide more extensive coverage, but for a different cost sharing parameter. So one of the things that you'll see, if you pick Sacramento as an example, is that if we look at the average of the 3 lowest price plans in that area, and I think there are 5 or 6 being offered, it's $337 a month for a 40-year-old. So it's important this is for a 40-year-old individual. And you can see the range there from Anthem, Blue Shield, and Kaiser offered. Now, I'll show you some comparisons to what that means to an individual that's subsidized at different levels, but I'll give my own anecdote. If I bought coverage for my family in Contra Costa County where I live, my total cost to buy that without any subsidy, because I don't qualify for subsidy, is actually less than what my previous employee contribution to my employer benefit plan cost, by a lot. So, the magnitude of these affordability is really astounding. And I think you'll start to hear more stories like that. I think the Bergdorf's versus Filene's comment about the New York exchange was along those lines too. So, okay, so one of the tricks, and I've alluded to this, is how do you compare the prices for an individual product to something that's comparable? So in Los Angeles County right now, you can buy an individual insurance product for as little as $70 a month. It doesn't cover much, and a lot of exclusions and a lot of deductibles. But you can do that. So what we struggled with, quite frankly, was how do you make a reasonable comparison to something where the benefits are roughly the same. So we chose the average of small group plans that had comparable benefits. And I think this is really important to note because there will always be a cheaper plan out there in the current environment. Whether you would actually want that plan for your family or not is a tough question. So this gives you an idea if you compare the cost of the plan to various, an average of small group comparable plans in the market today. And as you can see, they're roughly equivalent or lower, which is a great place to start. Now, if you start looking at what does an individual pay, because remember, this is subsidized based on the individual's income, it looks even better. So this is an average of what the individual versus the federal government in the subsidy will pay, again for a 40-year-old, and this is a statewide average, so we're just making an average out of all the regions. It's less in Southern California, more in Northern California, but you can see it's actually, for those that make very little income, say up to $117,000, they're paying $35 a month for their premium contribution, and then whatever copays they choose if they chose a higher cost-sharing plan. So you get to, say, a bronze plan where there's actually not that much cost sharing. An individual could actually choose a plan and be covered with free preventive health and a certain number of office visits included for nothing, and the federal government would subsidize that for $219 a month. So again, I think what's important here is that the amount people pay to get standard coverage actually is dictated by their ability to pay, up to 400% of poverty. And just as a reference point, 400% of poverty for a family of 4 is about $90,000. Doesn't mean that people can't buy insurance if they make more than 400% of poverty through the exchange, it's just they won't receive a subsidy. So what are the impacts? So not everybody wins financially in this. The people that will see probably an increase in premium are those that are currently insured but already make more than 400%. And that's largely because the benefits have been standardized. And so what they're required to purchase will actually provide richer benefits on average than what they've been able to purchase in the past. But here are the people that actually come out better because of this. Certainly the insured, and there are about 600,000 individuals that buy insurance in the current market, and as I mentioned, most through Kaiser, Shield, and Anthem. But there are still those that make less than 400,000 or 400% of poverty. They actually do get quite a benefit from buying through the exchange now because part of that is subsidized, and they are eligible for premium assistance. The uninsured, that's the other part that now is mandated to buy insurance, about 1.6 million, but also making less than 400% of poverty, they actually get premium assistance and benefit from that. And then there's also uninsured right now. There's about 1.4 million people that are uninsured but actually make more than 400,000. They too can buy and will need to buy insurance and can buy it through the exchange. They don't get a subsidy, but they benefit from those affordable prices that I showed. So I'm sorry if this is a little bit of detail, but I think it gives you the theme I want to leave you with is sort of what's in this for the individual that historically has not had a regular source of insurance or care. Also, we will offer what's called a shop set of plans. These are for small businesses. So again, people are not businesses are not required to buy through the exchange, but if they choose to, there will be a set of plans, many of the same ones, that will be eligible to buy their insurance as an employer through the exchange. What we're not, and again, this is sort of the there's lots of mythology out there. We're not government insurance. So, Deb, to your point earlier, I'd love to be able to dictate rates, in my sort of power control mode, I guess. But that's not our role. Our role was to organize a market for individual coverage and make that coverage both affordable and high quality in terms of the benefits, and also to ensure that the networks of physicians and providers are providing the care that's expected. Not government doctors, hospitals, or pharmacies, not death panels, not socialized medicine. I trained part of my career in the National Health Service, so I have a view of what socialized medicine can or can't do. So this might be considered a form of it, but we are providing an avenue for people to get regular care and to have insurance. This is our mission and vision. I think we take all of these seriously, and I think some of the ones that come back to what this group actually was most worried about were really the choice value and the healthcare quality. So this kind of comes back to how active will we be. And for those of you that want to dig into it, Attachment 7 of the model contract, which is available on our website, is solely devoted to clinical quality, network management, and delivery system reform. And I had a lot to do in constructing that, largely from input from a number of interested parties, not just plans and their representatives, but physician groups, consumer groups. In fact, 169 pages of comments on the first model contract to say, here's what you're missing. So that was our attempt to create a platform for high-quality, value-driven care. Now, can we get there overnight? No. Do we have a place to start? Yes. The question will be, what's our starting point relative to where we want to get? But if you're interested, some of the things that many physicians are very concerned about, patient-centered medical homes and things like that, alternate care models, those are addressed in that. I want to be careful of time, too. This is our timeline. I will say we are closing in very rapidly on open enrollment. Now, if you think about it, open enrollment is a point in time ahead of when people actually can get care through their insurance products bought on the exchange. That begins in January. I don't know too many people that enroll 3 months ahead of when they actually need the insurance, but some might. And that's really our test for whether we're set to go. And then we move out from there. And I should point out that this is, as it is in all states, funded by a very large federal grant, but the California Exchange has to become self-sustaining by 2015. So it has to run based on the funds it gets from its plan partners. Yeah.
Quick question. Yeah, to scale this and be ready to handle that flow, how many bodies are we talking?
It grows by the day. A month ago, it was less than 200. We are moving rapidly toward 400 or 500 now. Most of the people we're hiring are largely for the call centers that actually will aid in the enrollment. And what I'll show you is the enrollment counselors.
Okay. So after you go through your arc or your curve then to absorb, then you stabilize and your size becomes a little more
efficient. And then we have to function like any other organization or business. We live on how well we manage that fixed cost. Mentioned a lot about the affordable health plans. A big part, probably the second biggest part, is finding the people that are eligible, reaching them through the channels that are comfortable for them and familiar to them, and then get them enrolled. So as much as there are many other aspects of the exchange, these are the three areas that we're really focusing on now. Went through this in terms of what their experience is as a consumer. As I mentioned, 2.6 million are eligible for subsidies. And if you have standard benefits and you also limit the out-of-pocket costs and the total exposure somebody will have, that's what we believe makes this affordable. Okay, this is a bit of a eye chart, but I'll go through a few examples. This is the different benefit designs going from left to right, and the different levels of cost sharing. Remember, the benefits, the essential benefits are the same regardless of the level of cost sharing, and you can see things like preventive care, there's no cost, and things like that. What does this mean practically? A primary care visit, and this is for a silver plan again, for an individual, the rate is $45. That's what it costs the individual, and the out-of-pocket maximum for one for the entire year is $6,300. So that gives you some sense of the total financial exposure that an individual would face. Now, that's not zero, and that's a lot for most people that are that qualify for the subsidy, but it's not unlimited. It's not open-ended, and that's the peace of mind that people are looking for. If you start looking at this, though, by those that are income eligible or subsidy eligible, the consumer portion of this starts to decrease pretty dramatically depending on the income. And for that same primary care visit copay for somebody on the lower end of the income subsidy, it's only $3. So again, there was a lot of thought that went into how do you match the preventive health and other early visits to the cost-sharing parameters that allow people to access care. Another big thing I mentioned is reaching the people that are eligible. Again, this works well if we find most of the people that are eligible for insurance know they need to get it and get it through the exchange because there's a subsidy available, and that's kind of the journey that we're on. Kind of gone through some of these numbers. 5.3 million Californians are uninsured. About half of those qualify for subsidies. Another 2.7 don't, but will be required to buy insurance. And to get to that Medi-Cal question a little bit, there's another 1.4 million Californians that are maybe newly eligible for Medi-Cal based on the expansion of the income threshold to 138% of poverty. So the rub here is how do we ensure no wrong door, as people often say. You know, somehow find out about the exchange, or you find out you might be eligible for Medi-Cal, you go to one of those agencies. It isn't like, oh, you called the wrong number, try this one. We have to find a way to make sure people get a warm handoff to folks that can get them enrolled in the right program. This gives you a little bit of a demographic look at the subsidy eligible folks. As I mentioned, most of the people that are eligible because of their income levels are in Southern California, especially in Los Angeles County. So obviously, a lot of that effort needs to be geographically focused to reach those that are eligible. Again, to emphasize, though, we do have statewide coverage. So if you're eligible for a subsidy, there is a plan available, at least a couple plans available anywhere in the state. Looking at it demographically, almost 50% are Latino. Obviously, 2/3 are non-Caucasian, non-white. And this goes right to the heart of how to reach individuals in a medium in a way that they're most comfortable with. So this is not your traditional blitz everybody on standard television. This is reach them through street fairs, reach them through the community services that they want to use and are using, reach them through Univiz and Telemundo, those channels. So this has been a huge part of the early stage. In fact, I think the next slide has some more information about this, but actually part of the grant from the federal government is to fund $37 million in outreach grants that have been awarded already to community organizations that directly link to their ability to find people that are eligible. And there's a number, I'm sorry, it was 40. The difference between the two numbers is what's going through to physician-led and provider-led organizations to do the same thing. Enrollment's a big thing. Once you find the people and they understand that there's some benefit and some need to become enrolled, how easy or hard is it for them to get enrolled, especially if this is new to them? And so right now we are building a staff of certified enrollment counselors, very extensive training, helping them find not only the plan that they need, but potentially which plans offer which physicians and which hospitals. Because as I mentioned, the networks are different. They're not standardized. So part of my job early on is to make sure people know what they get when they choose a plan with a certain name.
And when will the networks be made public?
The networks will be made public at open enrollment in October.
Before then? Not before then.
I'm trying to push it forward. I've got a big meeting on that tomorrow. But clearly, it's I think it's one of those things where the whole enrollment process does take a time, and one of the big components of what people need to know is, what do I get if I choose one plan versus another, or is the plan that I recognize available in my geography?
And I think from a physician perspective, waiting till October to know where you are in this is going to
Too
be
long.
particularly if you're encouraging physicians and physician organizations to help reach these people.
Yep.
It would be helpful for those individuals to know how they're going to be impacted.
So I will take that away as a strong recommendation. We've heard it from the CMA and others. And quite frankly, it's a first-order question. It's great. I'm glad that a plan is in that I recognize, but can I get to my doctor? Can I get to the hospital of choice?
Physicians are getting those questions today.
So there are a number of ways folks can enroll. Again, this is part of, there's no wrong way to get enrolled. We're hoping that people will take advantage of the online service that's supported by certified enrollment counselors, but certainly paper applications are fine as well. So that's our website, coveredca.com. I'd encourage you to explore that a little bit. And I do want to, if I've got just a few minutes, I know we started a little bit late, but I wanted, and these are my slides, so they're not pretty, but I wanted folks to at least get some flavor of what's in that attachment that I referenced, so you can get some sense of what we're trying to promote. A lot of things, a quality rating system around plan performance, which standardizes traditional HEDIS and CAPS rates against the national benchmark and does so regardless of historically what these plans have provided, whether it's HMO, PPO, or Medi-Cal. Also looking at, to get to, I think the point that's been made twice, provider participation, like do they know they're in? What does that mean? And also the grace period, which for those of you that don't know about this is a very controversial issue about who's liable for claims if in fact an enrollee fails to pay their share of the premium. So we're taking that very seriously. Data submission, an expectation that we will, like many large purchases do now, take in data from the participating plans so we can have some intelligence ourselves, in an appropriate, HIPAA-appropriate way about what is or isn't happening on the ground with at-risk members, with wellness and prevention, with meeting the conditions of the contract. Looking at our own capabilities and the plans to determine health status, and also outreach for wellness and community health. How are plans supporting at-risk enrollees, and how do we support them in doing that? And that's, again, a strong area, not just for transitional patients that are going from high-risk categories into the exchange, but also for patients that aren't really known to the plans as being high risk but need that level of attention. A lot about patient and consumer information. I could go on forever there, but that goes everything from price transparency when there's price differences in a regional market, shared decision making, choosing wisely, programs to encourage appropriate use. Network adequacy and access, that's also been brought up here. And then there are a number of performance standards for plans, but I want people to understand that Covered California is holding itself accountable for many of those same customer service standards so that plans aren't feeling like we're holding the bag. We have our work to do too. So I'll stop there. I don't know if we have time for more questions, but that's the overview I had.
Deb, and then Dr. Yip.
Yeah, why did many of the national insurers walk away, Jeff? I'm just curious, because other than Anthem Blue Cross and Blue Shield, Kaiser Health Plan is California's, but why did all of them just walk away from exchange?
Again, I can't speak for them. But I can speak for their public comments, and the gist of their public comments, and I'm not quoting any of them, is that there was too many uncertainties to know whether this would be a profitable thing to do in the first year or not. Sharon, you may have heard the same thing. I think also the national plans, first of all, they were all for-profit plans, or the large ones that didn't participate, and second of all, they had a relatively small percentage of the total individual market, so there wasn't that much of a foothold or to work from. And with the uncertainties about who would enroll and what the risk profile of the people being enrolled would be, there was a sense that it might not be worth the risk to do. That's at least the comments.
Well, and I think also the California Exchange has more requirements of the plans. It has set a higher bar for participation. Some of the state exchanges are any willing health plan or insurer can sell on the exchange, and California is playing a role as an active manager of the gate, if you will. And I think some of the plans, as Jeff said, number one, how profitable it would be, and whether they wanted to put the energy into trying to meet those quality standards or.
The other thing I might add is that I think all of the ones that chose not to participate had said that they would reevaluate in subsequent years. And we started with a pool of 33 interested health plans and got down to 13. So some never really pursued, some dropped out later, that kind of thing. So I think it was really just a decision for each company whether they wanted to jump in the game at this point or not.
There's a saying that the pioneers take the arrows, the settlers get the land. Some of that may have been playing out here.
So I'm somewhere near the front of the wagon, I guess, right?
Dr. Yip, Ms.
What is
Yaroslavsky,
the
and then
expected
Dr. Lowe.
median age of these 4 to 5 million enrollees?
Generally, I'm sorry, the question was what's the median age of the, say, 4 to 5 million that we hope to enroll? In general, they're younger, younger than the average population. And it's a little bit unknown who will actually enroll, but the individuals that are subsidy eligible tend to be younger and healthier in general. There was I think it was either Commonwealth Fund study or another large national foundation that came out with some projections on that just today. So in general, I think they're representative of the population of those that haven't had insurance before, which tend to be young, working sometimes multiple jobs, families. And of course, what we tend to call the young immortals, the people that have never had to buy insurance and don't think they necessarily need to.
The reason we read in the news, Blue Cross, Blue Shield in the past raised the rates, Aetna, because they're too competitive, able to pay claims, and the rate is much lower than what they're charging. I'm just curious. I mean, maybe your answer because they're so young, so can survive on such a low rate. Otherwise, I don't know how this is going to survive in the next 5 to 10 years.
Well, some of that comes back to what the individual plans think they're going to get. And they made their own determinations from an actuarial point of view of where they thought they should price the product based on a number of things: the age, demographics, the enrollment, for the larger plans, the individuals they already had in the individual market. And there is a range of what premiums are being offered, so some were more conservative than others. We are hoping that we don't see a huge spike in premium prices next year. That will not be good. I think most people are pleasantly surprised about the affordability both here and in other states, but also cautious about what does that really mean. So yeah.
But that goes, who dictate how much primary care going to get paid, how much specialist going to get paid? Is it like Molina?
Yeah, it's the plans. It's the plans. And again, I'll reference Kaiser because they're in as well. Their model is exactly how they choose to manage their model. So we did not dictate that everybody use a certain reimbursement structure or, one of the things where we got a little pushback was that I was a strong advocate for a primary care assignment. Primarily, I'm a primary care physician, and I work in group practice models, and I think it's a good thing. I mean, if you have no other point of coordination, a primary care physician is not a bad thing to have. There were a number of plans that were encouraging us to not make that a requirement, so we've had to kind of move towards something that's less of you must have PCP assignment. But again, I think that's one of those where time will tell, and having the information on the back end about what is or isn't happening is going to be probably the best way for me to understand whether that's a good thing to require or not in the future.
Dr. Lowe?
So I would assume that, like in the Sacramento region, there are 4 insurers that are playing in this arena. So is there any limit on how much profit they can generate? In other words, even though there's some risk, I've got to believe that most of them think that they're going to generate some profit or improve shareholder value. 3 of the 4 are nonprofit, 1 is for-profit. And so I'm concerned that they're going to try to maximize profit and limit health care through a lot of different mechanisms, which makes it very difficult to practice as a physician. You know, they make too many hoops for us to jump through for authorization of routine testing. And the same holds true for medications. And so my concern is that they're going to make it very difficult for us to practice.
Yeah, I mean, I can't say that won't happen, but again, I don't want to give anybody the impression that we won't be doing some monitoring. I mean, certainly, we're going to expect the plans on a regional basis to provide financial statements about how they're doing or not doing. I think that the tricky thing, the 3 or 4 plans in Sacramento that you're using as an example, it's very difficult to tease out now profitability by line of business, you know, or profitability in a particular region.
See, at least if we have a managed care plan, we are able to call the Department of Managed Care and use their complaint line. But if it's a PPO, then we have to go through a less effective channel through the insurance commissioner. And it's not a very effective appeals system for the patient or the physician.
Well, again, this isn't the whole answer, but maybe helps a little bit. There is only one plan that isn't regulated, one plan product that isn't regulated by the Department of Managed Health Care in the exchange.
And which plan is that?
It's the HealthNet PPO, although the HealthNet HMO is. And they're offering both. And again, I should make people aware, these are new products. So it may have the same label, but the benefits are different, as I mentioned, and the networks in some cases are different than what's commercially available.
So something that is very basic to a lot of patients that need anticoagulation, you know, there's, of course, warfarin and the new alternatives that require no monitoring, but they're much more expensive. So will those patients insured through these plans have access to the newer agents?
We're not dictating formulary policies, just like we're not dictating rates, but to the extent that there are issues that we can use our purchasing power to change behavior, we will do that. If there's something, for instance, some of these forms that I mentioned, there's a number of chronic conditions where there's only certain specialty drugs that are even appropriate. So to the extent that that becomes a problem, I'm more than happy personally to convene the plans to discuss that. That mechanism never existed before in the individual market. But we're not creating a standard formulary, nor would I think that would overstep our role, for instance. Then we are becoming, I think, government healthcare. You know, then we are dictating how people practice and what they do. And that's clearly not the role of the exchange in any state at this point.
But I think we should eliminate those players that are mostly for-profit, whose sole purpose is to improve shareholder value. To me, they don't belong in healthcare.
Opinion not acknowledged. Don't know what to tell you. I mean, the excluding for-profit plans was not part of the ACA.
Dr. Gananadev, Ms. Yaroslavsky, Dr. Yip.
Just, Jeff, what's your estimation of how many people are going to switch from the commercial plans now through the exchange plans, like my group, which has 30 employees, I think we have, and one of the most expensive thing we do is the health insurance. And we, in spite of that, we get barely manageable health plans. So your benefit package looks much better. So are you looking at how many of the small employers you're probably going to go away from the standard insurance plans go through the exchange?
We are looking at that actively. Obviously, we would encourage people to purchase through the exchange or the shop if that's where they want to purchase. I think the question embedded in your question is, how do you as an employer, a small business employer, figure out what makes the most sense? Because if you can get better benefits at a lower price, that might be a better way to go. And right now, we're just now setting up what we're calling an employer task force, because it's not just, should I buy on the shop versus outside the shop, but should I actually provide some subsidy to my employees and let them purchase directly on the exchange? That's the more telling question. And I will say, from my experience at the Pacific Business Group on Health, there are some very large employers, not just small ones, that are wrestling with that question as well. Because especially as the rates come in, people understand that there are good reasons to do that, or to at least think about it.
So within the FQHC and the medical home model, will the medical home through the or the FQHC be able to apply through the exchange to the programs? Are they going to be or are the individual members going to have to shop these plans?
We had a very big push to include more essential community providers, and in fact, to your Dr. Lowe's question about how active we are with the plans, many of the plans submitted networks that we were not happy with, and we encouraged them consistently to add essential community providers. Now, and also non-essential community providers, just make sure the networks are adequate for the volume that you think you're going to see. Beyond that, we also are promoting what I've tended to call integrated care models, because one thing I don't want to get trapped by, and I don't think the exchange wants to get trapped by, is labels like ACO or PCMH, when we have some very, very good examples of integrated care that have been up and running for years. So it's not always about sort of the new models, it's about the existing models as well. So part of the trick for us is figuring out, we can't dictate what people put in their networks or what plans offer in their networks, but we can certainly encourage. And encouraging in a blunt way probably won't work as well as saying, we've identified these members in your plan that don't seem to be getting as coordinated care as we would like to see. Can we talk about how we move them into a coordinated care model? And I had this very conversation with the chief medical officer of a very large academic medical center yesterday, where they're participating through 2 different plans, but their goal would really be to take on more shared risk and shared responsibility than rather than just more volume in the old paradigm. So to be determined. But the other problem in general with the labels, I'm a big fan of patient-centered medical homes and accountable care. The challenge is whose definition counts. So if we really go down a road of credentialed or certified patient-centered medical home, that becomes a very small subset of the total that are emerging out there. So part of it is how do we stay flexible as well and not get locked into regulatory compliance type definitions. I'm sorry, I hope that at least gives you an indication.
Dr. Yip.
Since Dr. Lowe opened the can of worms, first of all, I do admire people like you who spend the time, energy, and help this thing. I think it's a good thing for everybody, for California and all that. But I do see problems down the line. I see product like this works really mainly with Kaiser Institute or big non-profit hospital chain. It's a good thing you have all these different plans because you have instant access. Its bad thing is a logistic headache. As you say, you cannot dictate the rate, you cannot dictate what it is. You don't even have the central formulary. You don't have a central, maybe the utilization review really look at individual plan, what is standard there. And I can tell you from my experience that LA Care is a chaos. It takes 2 weeks to get something done, like a cystectomy. It takes me 2 weeks to get a bag for a patient. Not that they're not doing a job, it's just the logistic they have learned through that. But organizations like you, I don't think you can just say, well, they are the one doing that. I just pay the rate. I think someone needs to control all that so that you would not discourage patients from enrolling, so you will not discourage doctors from enrolling.
Mm-hmm.
I sat in a meeting with Diane Dooley and also LA Care before, and one of the concerns with specialists is that patients go from hospital to hospital, they don't even know the primary care doctor. And because of that, they get in the hospital, they don't belong to Molina, they may belong to that, they got shipped around all these hospitals. I have a patient travel 30 miles by ambulance just to see me so I can take a kidney stone for 30 minutes. And we have neurosurgeon, orthopedic refuse to take call in ER because they don't want to stuck with a patient like that. It's not just a headache for them to get authorization for care and liability. I think someone above those plans need to do something to put it all together. My suggestion to the secretary at that time at LA Care is that certain shortage, especially maybe cardiologists, neurologists, orthopedic, the plans or cover California have a direct contract with those physicians. So the patient would not go to a certain hospital, and doctors say, I'm not contract, so I'm not going to touch a patient. Then it become a coordinated care issue. That's what I think.
Yeah, we're trying, yeah.
Yeah, I think all I can say is that I don't think Covered California in its first year is going to solve all the problems of the current healthcare system. On the other hand, I think getting enough people enrolled so that we have a platform to move in that direction is really important. If we do not consolidate enough purchasing power within Covered California, really we can't, not that we would dictate anything, but we can't suggest anything. So I think job one is to make sure that the exchange works in terms of affordability and enrollment, and then we have a platform that we never had for maybe 3-4 million people to actually start to have, you know, a real chance at fixing some of those things. And I certainly can't say that we would, you know, direct contract and things like that, but I know until I know where the problems are, I don't really have much to talk about. And I know there are many health plans and provider systems associated with those health plans that do a fabulous job that are participating. So it would be, you know, not appropriate for us to say we're going to dictate how the system works, but I think we can try to find the problems and maybe suggest some fixes.
I certainly appreciate the presentation, and I've tweeted you and Facebooked you, and I'll let other people decide for themselves. And, you know, really with that, as a part of any form of creation, there will be failure and reinvention. So just keep an open mind and good luck.
Thank you. I'm old school. I don't use Facebook or tweets too much.
Well, they're on
I'm
your
not even
page.
on LinkedIn.
They're on your website, which is good and easy to get to.
So.
And you've been shared, so.
I'll give you my cell phone number if people still use phones.
That's why you hire staff to do this, you know, it's
That's
that
right.
expense.
Oh,
You said that you're making these presentations throughout California. How can we arrange for you to come to a community or have someone come?
The community presentations we're making are town halls in major centers like Riverside and Orange County and other areas, but
How about Long Beach?
we have.
Long Beach? You're not scheduled in Long Beach yet?
Well, I'll leave either my card or
Okay.
we can just talk afterwards. But I'm happy to come out and talk. I do a fair amount of it now. Just to give you an idea, we had last week alone 170 requests from various organizations across the state. So we're anxious to get out there. Part of it is we have to prioritize what we do.
Because we had Insurance Commissioner Dave Jones come out to announce about Covered California without the details, and we did this at Memorial Hospital in Long Beach, so if we could get you back and talk about, now that you're up and kind of running, it would be very helpful.
Okay.
I'll get your card, thank you.
Thanks.
Great. Can I ask if there are any comments or questions from members of the public for Dr. Rideout? If not, thank you so much for your time and thank you for coming. We are going to move on to Agenda Item 5, discussion and consideration of proposed regulations in implementing SB 1441, which are the uniform standards for substance abusing licensees, Mr. Hepler and Ms. Dobbs. Just Kurt? Okay. Mr. Hepler.
Thank you, Madam President and members. The item before the board at this time is the consideration of regulations that would formally adopt the standards relating to the Medical Board of California discipline of substance abusing licensees. Please, before I address these proposed regulations specifically, allow me to provide some background information. As I'm sure all the members know, whenever the Medical Board of California exercises its disciplinary, licensing, or regulatory functions, consumer protection is its paramount priority. That's in statute. We are considering regulations. The purpose of regulations are to implement, to interpret, or make specific certain portions of statute. These regulations before you today are the mechanisms to implement the standards set forth by 1441 and formally adopted by the Department of Consumer Affairs Substance Abuse Coordination Committee. Let me give you a little historical background. For the new members, and perhaps for some of the old members, the Medical Board of California used to have a diversion program. It wasn't a contracted diversion program. It was a sort of self-administered diversion program. There are three ways, essentially, to get into that diversion program. You could self-refer, the voluntary option. You could be ordered into it by a disciplinary order. The board, through probation or some other disciplinary proceeding, would order a licensee into the diversion program. The third way to get in is where the word diversion comes from. It's a statement of understanding, and it was sort of the agreement that you would enter into the diversion program, and if you successfully completed that program, there would be no follow-on discipline. That's the so-called SOU. Now, as the board begins to deliberate on these regulations, please be advised that even if these regulations are adopted, the Medical Board of California will not have a contracted diversion program, nor will it have a self-administered diversion program. These standards will come into place when a licensee is disciplined. As I said, no SOU, no statement of understanding, no self-referral. Will the adoption of these regulations bring back the former diversion program? No, they will not. Will these adoption of these regulations implement a contracted diversion program? No. Will the board continue to have substance abusing licensees? Regrettably, probably less. Yes, I'm sorry. There are 16 standards that were set forth by the SACC, the department's committee. Not every one of those standards is set forth in the regulations before you. Standards 13, 14, and 15 deal with contracted-based diversion. Those are not applicable. We don't have contracted diversion. We don't have self-administered diversion either. So standards 13, 14, and 15 were not included in the regulations you see before me. Let's talk about Standard 16 for just a moment. Standard 16 essentially instructs the board, not a licensee, instructs the board how it's going to collect data and how it's going to report on that data and how it's going to analyze that data. Clearly, in my legal mind, this standard is applicable to the board. The question is, generically speaking, is this standard ripe to be included in the regulation? Respectfully, and I know it's probably a matter of some controversy, I'm going to say no, because this is really governing the internal procedure of the board. It really doesn't touch a licensee. It touches how the board collects the data and analyzes and ultimately going to decide whether or not the diversion program is successful or not. I don't believe it's ripe for incorporation into these regulations. Let me also point out candidly, there is a mistake in our regulations. If the members would be so kind as to turn to page BRD 5.5, under numeric number 5, biological fluid testing, subparagraph I1, it says the board may revise the frequency specified in section I upon a determination that the licensee is not currently employed by the healthcare field. And the erroneous language now reads, the licensee suffers from a substance abuse disorder. What we're really talking about in section 1 is a sort of diminution of the testing frequency. And so that, I've compared it to the existing standard, and it should say the licensee does not suffer from a substance abuse or abuse disorder. So my drafting error for that, I do apologize. Madam President, members, the balance of these regulations, the balance of the standards have been adopted in these proposed regulations. I know the time is of the essence. I can go through them one by one if you like, or I can just simply say, like, with the exclusion of standards 13, 14, and 15, and 16, 1 through 12 have been incorporated in these regulations. If the board sees fit, the proper motion would be to set these matters set this matter for public notice and hearing at the next available board meeting. And with that, I'll be quiet and answer any questions you may have.
Sure,
You want a motion for purposes of discussion?
sure.
So I make the motion.
Okay, any questions or comments for Mr. Hepler? I have one.
Yes, ma'am.
You referenced, you pulled out standard 16,
Correct.
and I guess perhaps I'm misunderstanding this, but it appears that it isn't just about internal procedure, but it also requires a report on a yearly basis to the DCA and the legislature.
Correct.
And it isn't just about diversion, it's with licensees with substance abuse problems who are either in board probation and/or diversion.
Correct.
So,
No, Madam President, please understand, I believe the board is bound by that obligation to collect and report. Please don't understand me, I'm not trying to suggest that we are not. What I'm trying to suggest is I don't believe that the regulations are appropriate as a mechanism to do that. I believe they're bound by statute to do this already. So it's not an evasion or aversion of trying to do our responsibility. If you notice when you talk about some of the regulations, it's like, and the board shall issue a cease practice order. That directly affects licensees, we can see that. What I'm suggesting is this, we're never going to discipline a licensee for not collecting the data. Okay, they're kind of different. But like I said, just to repeat myself, unnecessarily, I'm not suggesting the board not comply. I believe they're bound by statute to prepare the reports and the analysis. What I'm suggesting is that it's not ripe for incorporation into the regulatory package. That's all.
because the standards are for substance abusing licensees.
Correct, and this is essentially, if you think about it, we're going to collect and report on data.
Thank you. Thanks for the clarification. Any other questions or comments from board members? I have several comments from members of the public. Ms. D'Angela Felmuth.
Good afternoon. Julie D'Angelo Felmuth from the Center for Public Interest Law at the University of San Diego School of Law, also the former Medical Board Enforcement Monitor. By way of background information, one part of my duties as this board's enforcement monitor was to audit the former diversion program. And so I'm very familiar with it and with all of its failures and loopholes. This board's unanimous decision in 2007 to abolish its diversion program is what led Senator Ridley Thomas to further investigate the diversion programs at other healing arts boards. And it prompted him to introduce SB 1441, which required the formulation of these uniform standards and their mandatory use by all the healthcare boards. I attended all of the meetings of the Substance Abuse Coordination Committee, which formulated these standards, so I'm familiar with them. And I'm familiar with the way in which other boards are adopting regulations to implement them. Now, some boards are simply adopting a regulation that says, in a disciplinary matter involving a substance abusing licensee, this board shall comply with the April 2011 version of the Uniform Standards for Substance Abusing Licensees, which is hereby incorporated by reference, period. That's the easiest way to do it, and that ensures that all of the uniform standards are incorporated. Your council has chosen not to do that. This proposal contemplates a rewrite and a reordering and a renumbering and a paraphrasing of the uniform standards, and the incorporation of this rewrite into a new regulation, section 1361.5. Now, that's not necessarily wrong, and I concede that the uniform standards are not a model of draftsmanship. But it's just harder to compare the proposed regulation with the existing uniform standards to make sure that everything in the uniform standard has been included in this new regulation. And I have found some omissions, some potentially important omissions that I just want to point out to you. First of all, on page 5-3, toward the top, parenthetical 2, clinical diagnostic evaluation and reports. This number 2 here collapses Uniform Standard Number 1 and Uniform Standard Number 2 into one subsection, dealing with this initial clinical diagnostic evaluation that a probationer, a substance abusing probationer, has to undergo. And it addresses the fact that that person, that physician, has to cease practice while undergoing that diagnostic evaluation and while its results are being compiled and reviewed. This is okay, but it omits a key provision of Uniform Standard Number 2, which is on your page 5-13. And it says, no licensee shall be returned to practice until he or she has at least 30 days of negative drug tests. That's not in here, and it should be. Next, on page 5-5, in the middle of the page, you have parenthetical 5, biological fluid testing. This is similar to Uniform Standard Number 4, which includes all the requirements for, sorry.
Wrap it up.
Oh, okay. I can give the rest of these omissions to Mr. Hepler, or I can tell you what they are. What is your pleasure?
Well, since I'm being skewered, why don't I?
No, you're not being skewered. I'm just. I'm happy to give him the omissions, the other ones that I've noticed, just so that, just FYI, he's correct. You're going to adopt a regulation and it needs to be approved by the Office of Administrative Law. One of the criteria they review for is consistency. Your regulation has to be consistent with the uniform standards, and to the extent that it's not, OAL may reject your regulation. So I want to make sure that they're as consistent as possible, and I'm happy to give them to him.
Great, thank you.
Madam Chair, for one, I would, as a board member, like to hear what the inconsistencies are. If possible, I don't know how long that's going to take, but.
Madam President,
It's
if
not
I could
gonna
be
take that
so bold,
much
I think Ms. Shipsky and Ms. D'Angelo Filmuth are exactly right. If I could ask the board's indulgence, I think since we're kind of on an issue, respectfully, I would suggest the board may want to consider granting her additional time just for the purpose of delineating the emissions.
Completeness.
Thank you.
Point of clarification before we continue. In these matters, especially when we're dealing with adopting new regulations, I just would suggest it would be helpful if suggested comments and modifications would be submitted in writing, and then we could look at the language. And then it's not done on the floor, more so in the context of an opportunity to amend, look at the structure, look at the meaning, do a little cleanup work, and then go forward beyond that. This body does have the ability to, at any point in time, modify a regulation and adopt an amendment. And clearly, we always reserve the right to direct our council to meet and confer and take under advisement other language changes for final review, just as a suggestion. With that, the chair's pleasure.
Great. Then I think I will ask you to finish. And can you, it sounds like, can you distinguish in doing this between it's in a different place versus it's completely missing?
Right. What I'm pointing out are things that are completely missing.
Okay.
Okay, back to page 5.5. Parenthetical 5, biological fluid testing. Again, this whole 5 is similar to Uniform Standard Number 4, which deals with all of the requirements relating to drug testing, including random drug testing on a date selected by a computer. There are 3 omissions from Standard Number 4 that are of concern to me. First of all, on page 5-17 of the standards at the top, it says, you want me to wait till you get there? Okay, 5-17.
Can I ask you how many more we got?
I got,
I just got, trying to manage the.
I got like 4.
Okay, great.
Okay. It says, licensees shall be drug tested on the date of notification as directed by the board. That statement is not in this regulation, and it needs to be. It's important because one of the major flaws in your old diversion program was the fact that random drug testing dates were generated by the program, and those dates were distributed to specimen collectors all over the state, who then would unilaterally change the date of the test to suit their own convenience and schedules. And what I found was that they routinely moved testing off weekend dates and holidays and onto Tuesdays and Thursdays, which then gives the participant an opportunity to game the system. I found this flaw, and the Bureau of State Audits found the same flaw 2.5 years later. It was still happening. So that sentence needs to be put in here. On page 5-6, continuing with drug testing, when a probationer is out of town or on vacation, drug testing needs to continue. Uniform Standard number 4 at page 5-17 requires that any alternative drug testing locations be approved by the board. That's not in here. Again, on 5-6, we're still talking about drug testing. At the top, it talks about how quickly the laboratory must notify the board of a positive test. This regulatory language says within 7 days of receipt of the specimen. That's not what Uniform Standard 4 says. At page 5-17, it says the board should be notified of non-negative drug tests. That would be a positive or a dilute within 1 business day, not 7 days.
Well, wait a second, let me, and Claire, I'm reading the same thing she's reading. And it says within one day, and will be notified of negative test results within 7 days.
Are you on 5-17?
Yeah. So I just want to, if we're going to be looking at what's missing, I want to make sure we're looking at that.
5-17 says, in the middle of the page, the paragraph starting, a collection site must submit. The appropriate board will be notified of a non-negative test result within 1 business day, and will be notified of negative test results within 7 business days. The way this is worded, I've lost it now.
Now, there's an omission. I have 7 days results. I do not have,
Right, you have the 7, you just don't have the 1 for
So
non-negative.
it's the one that's missing.
Right.
yes.
Got it.
Right. Uniform Standard number 12 concerns petitions for reinstatement. That's on page 5-28. Here you have a licensee who has been put on probation for substance abuse, subject to these terms and conditions. Standard number 12 sets forth the demonstration that a substance abusing licensee has to make before that probation can be lifted. That's not in here at all.
That is by design, members. Candidly, we don't, some of this flavor of 12, candidly, is a flavor of a diversion program that is contracted. We don't have this mechanism by which we have essentially, if we find somebody who's violated their probation, we have the official mechanism to petition to revoke that probation. So I'm going to have to respectfully disagree with you.
I'd like to address the members on this as well. I was very involved in the drafting of SB 1441 uniform standards. I was on the work group. I was very involved in this when we put this together. Item both, I believe it's 11 and 12, one talking about putting people back into full-time practice, as well as the one putting them back into practice when they're not at all part-time practice. This specifically had a standard, and if you look at 5-28, you will see under number 12 that it specifically states petitions for reinstatement as used in this standard is an informal request petition as opposed to the petition for reinstatement under the Administrative Procedures Act. When this was drafted, we were not talking about individuals on probation. We were talking about those who actually were in a probation program and those individuals going back into the practice of medicine after a diversion or a monitoring program had suspended them and what they needed to meet. That was the intent of this section, I know because I was there. Petitions for reinstatement have specific language under the rehabilitation. I believe, Mr. Hepler, I'm not sure the section, that we have our own requirements in statute that requires them for rehabilitation of areas to meet, and I can specifically state to that, number 12.
Madam Chair, it's getting pretty confusing to me, sitting here trying to look at each section. That's why you put them on there, have the comments and all that. I would recommend that rather than us trying to decide right here, trying to go through statute on one side and what our staff wrote, the regulations, and trying to decide that it's getting to be beyond attention span leaving kind of status right now. So that's why I'm not sure we can take everyone who is given a chance. Everyone will have issues because they can all comment. That's what public comment period is. So that's why I was wondering, is it really, is this the right place to go through? That's what my entire point is, that is, in detail, is the right place for the board, or let that be a public comment period and with the staff working on rather than here. I'm looking at a bigger picture rather than trying to do here.
And I think there was a request to at least understand what the omissions were, rather than have a dialogue about them. And that's what Ms. Felmuth was asked to do, was to point them out. And you had one more, I think?
I think I do have one more.
And if we could just let her get through that, and then take it offline, and Kurt
Right.
can.
Discuss.
Also, uniform standard number 6, which has to do, it's on page 5-20, has to do with standards that should be used in determining whether a probationer should be referred for some kind of treatment, a detoxification type treatment. That's not in here either. The final one has to do with standard 16, which is that record keeping and reporting requirement. I agree that it doesn't necessarily affect licensees, but I believe that it should be included in your regulation because it goes outside the board. You have to report this stuff to the Department of Consumer Affairs. And this is a transparency matter. And I would strongly encourage you to include standard number 16 in your regulation. Thank you for your patience. I know that these are going to be set for hearing. There will be a public comment period. I can submit comments in writing, but I just wanted to have a chance to correct some errors before you even notice it. Thank you.
Thank you very much. We have one more public comment on agenda item 5. Michelle Montserrat Ramos.
Good afternoon, board members. My name is Michelle Montserrat Ramos, and I'm from Los Angeles. I am with Consumers Union California Safe Patient Network. I testified on March 10, 2008 before the Senate Business and Professions Committee on the topic of substance abusing physicians. On that day, former Senator Ridley Thomas took the consumer perspective in consideration when he authored SB 1441. In the past 5 years, we have sought to have the uniform standards implemented. We have met with board staff, Department of Consumer Affairs, and legislators. Unfortunately, it has taken 5 years to get to this place, but fortunately, we are finally here. We urge the board to adopt the staff recommendations that the board place the uniform standards into regulatory language rather than including them in its disciplinary guidelines. As you know, while the board's guidelines are discretionary, the medical board is compelled by law to follow uniform standards in addressing substance abusing physicians. In regards to uniform standard number 16, we agree it should be placed in regulation. We think it is important that the board be vigilant in ensuring that this report, which will provide some transparency for members of the public, is thorough and prepared timely and distributed to the legislature and the Department of Consumer Affairs. We appreciate the board's attention to this critical issue of fully adopting uniform standards for substance abusing physicians. Thank you.
Thank you very much. Any other comments from members of the public? So it sounds, if not, and I don't see any hands, it sounds like we have a decision to make. We don't have language to vote on today, so we can't really vote on the language and set this for hearing. Is that correct?
Can't we do it as a placeholder?
Can we set?
We actually have the language in front of you on 5-2. What we don't have is some of Ms. Falmouth's edits now in writing, in the language.
So can we schedule this for hearing, realizing that we're going to see edited language? Is there a problem with doing that?
Diane, what do you think? I'm a little bit
I'm not a lawyer, so I
Right.
need some help here.
I am one.
That only adds
I
to the
play one on
confusion.
TV, too.
Yes, right.
Point of personal privilege, and point of order, just to, as we look at how we want to address this on an ongoing basis, we noticed this item, the materials are made available, public's had an opportunity to review, and in this case, opine. The question was, are any of those comments, besides being part of testimony, made available to the staff prior to the meeting? So there's opportunity for response and/or amendment if there was language cleanup needed or inconsistencies. This being the case and not being able to weed through all the detail of it right now and have it vetted, my recommendation, if it would be supported or considered, would be to table the item, calendar it for the next meeting, give the staff the opportunity to make that review, and then come back with their position. Clearly, in the future, we would suggest, and I would suggest, that we hold pretty firm to say if someone has a comment or a change or an opinion, to make that, have a cutoff date and say, hey, we're going to take public comment, and beyond that time, that's what's coming to the board for us to approve or reject. If there's something that's found beyond that, we always have the ability to go back and adopt a modification or amendment in the due course of business.
Ms.
Okay,
Dobbs?
so what you'd be asking for is to notice it, but you wouldn't know what you were noticing. You wouldn't know all of what you were noticing. So if you're comfortable with that, I would say you can go ahead and notice it. But I think the best practice would be to know what you're noticing, even though there may be edits later on. I think it's best to know at least what you're noticing.
Which I think is what Mr. Tagami is suggesting.
I'll get in the queue and respect my other colleague, and then I would like to.
I just want us to be cognizant of the fact that this has taken a long time coming. We need to move on this in a positive way and have regulations, that there are some omissions that need to be considered, or changes or edits that the public is going to want us to consider. That so be it. But we do have the copies in front of us of where we're trying to go. So my concern is, by waiting, and I would agree normally with Mr. Tagami on principle, but the idea of waiting till October to start all over again pushes it back. And my concern is, how is that going to be perceived by the public, by the consumer, by the powers that be within the state? So I would just, okay.
Here it is, and so I put it out there as an option. The alternative is to move the item, review it, discuss it. If we want to approve it with the knowledge that if there's something that's fatal or really is problematic, then it can be amended in October, as anything else that's in the regulation that staff could put on the agenda and say, hey, we're bringing this back, because in the review, we did find this, that, and the other. If you need to cross the Ts and dot the Is, or do any language cleanup by way of reference, indirectly or directly. So, again, I'm not a lawyer either, so.
Either. That makes it, we can
So,
talk.
2 key points. So respectful of the fact that there's been a lot of work done on this, acknowledged. Respectful of the fact that there seems to be a degree of urgency, acknowledged. But there's also needs to be responsiveness to the public, and/or if something was found to be lacking. And so, to meet the board's, just to bring it to a conclusion, Madam Chair, I'd be willing to move this item, approve it as it's submitted, with direction to staff to meet and confer with the members of the public who have interest, present and/or not present, over a period of time, and calendar this to bring it back if, in fact, language changes rose to the level that required amendment, and present that at the time.
So what I'm hearing is you're moving to adopt the language, noting that it appears there's no disagreement on content, there is potentially the need to add back some language that is already present in the disciplinary guidelines.
I think there's in the standards themselves.
I'm sorry, in the uniform standards, right, that's what I meant. And so it's kind of, in a sense, I think we do know what we're voting on. We're voting on the language Mr. Hepler has presented, with the potential for the addition back of some language that, as it is written in the uniform standards, back into the regulatory language, and noticing that for regulatory hearing, so moving it, approving it, and then noticing it for regulatory hearing at our October board meeting. Is that
Correct.
Well
So-
stated, very well stated.
Yeah, this would give the board, as Mr. Takami has pointed out, this would give the board the opportunity, as we usually do, and is required by law, to consider all oral written comments. If we do receive those kind of comments, and we would, if they're substantial related, we would go out for 15 days, take the amendments. So what this really does is essentially get the process, the formal process started, so that we can entertain public input, both oral and written.
great? Can I have a second?
Oh.
Seconded.
You had a
and-
motion on the floor to start with,
Yes.
but that's okay.
But this is a different,
Okay.
somewhat
More clarifying.
amended motion. I had
Consider it
two,
a friendly amendment.
I have some questions. I think for purposes of, maybe newer board members, because I remember my very first meeting I walked in was when the diversion program was being tossed out, and that was quite an interesting meeting. But I just need to point out, in all due respect, that when Julie comes up and gives testimony, she's not just a member of the public, she was the appointed monitor of this board, and knows, I think, as well as staff does, the ins and outs of what went wrong in the diversion program and why we need to step up and get these uniform standards going. That being said, and the other thing, I think Phil's comment about having public talk with staff ahead of time. I've been here 7 years, and that has not been the process ever, that if there's an agendized item, the public comes forth, makes a comment, and at that time, staff takes that commentary. So if we're going to move in that other direction, that would be fine, but I think that we've been following this for many years, that at the time of public comment, people come up and at that point express their concerns. I don't want to do anything that's going to slow this process down, because I think the board has been very clear we need to move on this, but I would hope, that the commentary that she provided is somehow going to be incorporated, because what we don't want, folks, is another monitor appointed because we aren't doing our job, or we get such public outcry because here we had an opportunity to really clean things up and there's gaps. So that's all I would hope, that if we're going to go forward on this, that somehow we get this worked out, and that it proceed with the recommendation.
in case I wasn't clear, I think what I stated was that the language that would be set for a regulatory hearing would be inclusive of the insertion of the omissions.
If there are any.
I don't know that we can do that, can we? Because we
I think that this is starting to be a discussion about a discussion about a discussion.
What I would respectfully
I think we
suggest,
need to
members,
move the
this,
question.
this is, something that, obviously there's a few omissions. What I would respectfully suggest, I'm certainly cognizant of the things that I missed. I don't know exactly, word for word what they are. I have a global picture. I think the board would best be served by setting what you have here for for the rulemaking thing at the next meeting. That way, it's formally noticed, people can submit comments, we can come to the board meeting, we will have, literally, when they send in written comments, we will know what they want and what they have amended.
So it would not include the dialogue that we just.
Respectfully, I would suggest it be sort of a pure thing where we just set it for hearing.
Okay.
I think that'll draw out the comments. Certainly, if someone wanted to, send some comments by the end of the day today or by the end of next week, the board would certainly entertain those and consider those moving forward. So that would be my recommendation.
All right.
I would just say that obviously we have some, staff would have some work to do to prepare for the upcoming meeting.
All right, good.
Madam Chair.
Mr. Takami?
So on the motion, and listening to what staff's saying, and respectful of my colleague's comment regarding process, I think it's highly advised, and I think we would always be well-suited to encourage our staff to be very receptive to anyone in the public providing written comment or even verbal comment regarding suggestions and/or amendments or modifications, or highlighting any omission that could be noted literally in the context of, this was what was in the packet, this has been brought to our attention, we think some language cleanups required. I think that's totally okay, and I think that demonstrates not only outreach and awareness, but also sensitivity to the public's involvement, and increases public engagement and responsiveness. Having said that, I'm more than willing to withdraw the motion if our staff attorney's suggestion is one that suits the board's desire, I think ultimately respectful of my other colleagues' comment that this has been some time coming and there's a degree of urgency that we need to move forward. Don't want to see this, literally relegated to October with lack of action.
So so you're withdrawing your motion?
Well, up for discussion. I mean, that was discussion regarding the motion on the floor. I expressed my willingness. I think there needs to be a consensus here in a direction to move forward.
So we do have another motion on the floor.
So I would, as the maker of the motion, I would want to hear from our interim executive director, as well as our attorney. I've heard from, I like the amendment, so I'm not quite ready to give it up yet. But by the token, I can appreciate the issues. I'm surprised that the assumption has been that the public is not entitled or expected to or want a desire to
Encouraged.
have approach to send in information. I found that I thought that we were a little bit more open than that, and I apologize if that's been the perception out there because it wasn't my perception. But by the same token, I would rather hear from staff as to what the effects, pros and cons are going to be. But I want it to come in October. I'm not going back further than that.
All right, so Mr. Hepler's recommendation is that we move the language that we have to set for hearing in October, and that we set a regulatory hearing. He is going to work over the next week, 10 days, to incorporate what he currently understands needs to be incorporated. Any further additions, amendments, or changes can be noticed or amended and changed through the regulatory hearing process and through comments from members of the public.
So that's good. I'm clear that, so what I'm hearing is that there's going to be an incorporation of what has been heard so far, and we're going to move forward. Then you don't have to take away your amendment.
That's right. So,
Thank you.
Yeah.
Madam President, there's nothing preventing me or Ms. Webb or Ms. Dobbs from, at that meeting when we have in October to go, here's a big mea culpa, here's the stuff we missed. Here it is, members, as we consider this.
You have absolution.
Yeah, okay.
So I'm still looking for the language of what the motion.
I think if Madam Chair, if I may, I would be willing to accept our council's version as the amended and restated motion. I believe there's a second to that, and if that's appropriate, unless there needs to be further discussion, we can call the question.
And I will call you okay?
Yeah, I'm okay with this, certainly.
I just want to be sure everybody understands.
I don't. I'm not clear now if we're going with the current language or you're going to accept some of the input that said there were some omissions and you're going to incorporate that. Where do we stand right now?
So what my understanding is, we're going to set this for regulatory hearing with the understanding that staff, that would be me, is going to focus on the omissions that
So we don't have to have those omissions pointed out in October. We've heard them now, they could be incorporated.
No, they will, the people, those omissions, my new language, so it'll be, what we'll be considering in October will be this language, plus all the things that I've missed, plus anybody that has anything to say at the upcoming October meeting. So we're going to set this for regulatory hearing. Your staff commits to the fact that he will work with any interested party who wants to send him stuff to figure out what he's missed. Then we will bring this and the list of omissions to the October board meeting, and it'll be deliberated on that. So that's kind of what we have so far.
I just have to say, because I think our sentiment is that we want to be in compliance, and we're not looking for an explanation of why we're not, that we want to be in compliance.
No,
I
I
think
think
that's the sentiment.
So may I just add
Understood.
one thing? So let me just further add one clarification. So at the regulatory hearing in October, the document that will be up for discussion will be this document plus the things that are missing.
Good.
That's what the hearing is going to be about. So it's going to be all of the language.
And anything that comes to light at the
And
hearing.
anything else that comes in light, yeah.
Alternatives for consideration.
So,
Right.
just, I'm not a lawyer, and I don't know much about setting regulatory hearings. So when we use, when we use the term, we are going to notice the language.
Right.
Exactly what happens.
So what that involves is essentially, we're going to go through the lawfully adopted standards, and we are going to tell the world through the publication of a notice in the proposed text in our final statement of reasons. We're going to publish that in the regulatory register to say, dear world, the medical board is considering the adoption of this regulation. Here's the comment period. Here's when it's going to be scheduled. Here's the notice. More importantly, here's the reasons why we're doing this. Everybody then who reads that will have the opportunity to offer written comment during the comment period, and will have the opportunity to come to the board meeting and testify as to any changes or the non-adoption or whatever they wanted. So when we say set it for regulatory hearing, what that means, staff's going to prepare the documents to tell the world that we're embarking on this adventure of regulation.
And when you send your Dear World letter, will the language be what you brought to us? Or
Yes,
will it
will
be?
this. It will be this.
It will not be amended in any way from what's in this book?
Correct. It will be this.
Madam Chair, we can't vote on something which will be amended later on, so I'm taking it granted that that's what it is going to be there. And then the staff would work with anyone who comments, and that will come to October meeting.
I just wanted to be clear that we understand what we're voting on, that the notice that will be noticed, we acknowledge up front, will not be what we anticipate the final document should be or will be.
Correct. Right, it will be, certainly it's within the power of the board as it deliberates to go. And we think that's a good idea, and we also think these things you omitted are a good idea to be included as well.
Right,
So, and we have a motion on the floor that Ms. Yaroslavsky,
and then the friendly amendment, absolutely.
there's no amendment. There's no amendment.
What we asked was,
Yeah, we did.
in the record, I communicated some specifics. I would like to think our council cleaned that language up a little bit, and I'm willing to accept our council's version as the official version to minimize any confusion or ambiguity
Okay.
as it relates to the record.
But understanding that council will be working on a cleaned-up version, but what will
I'm
be
talking about-
noticed.
I was clarifying my motion.
Right.
So the words, the language of my motion for the purpose of the record, so if anyone wanted to go back to it, that was the direction we're giving our staff.
Okay. Is everybody clear now?
Crystal?
As mud.
All right. All in favor?
Aye.
Aye.
Aye. All opposed? Any abstentions? Okay.
Madam Chair, can I get clarification? Because I think we don't want to have this hanging out there, that if there is an agendized item, that the appropriate route of conversation is to direct the correspondence to the board, not to the staff, because we're a legislative body. And that agenda, to go to staff, I think to go to staff directly when it's already on the agenda and we have not yet discussed it, I think it should be provided to us as a public comment. But I know, as a city council person, if we have an agendized item, it goes to the city clerk, any public comment, and then that public comment is shared with us, so that it doesn't go to the planning department staff. It doesn't.
Right.
It goes directly to the
Can
clerk.
I get in on that? I think, again, so correspondence to the Medical Board of California comes to the Medical Board of California and is distributed appropriately to all parties involved. And clearly, the more
Including
informed, the better all of us are, and hopefully responsive as well. So,
Right, I meant including staff too, but I just, very
so-
clear that the public communicates with the board, and then it can be disseminated from there.
So,
This is starting to be a little bit.
it's okay. I'm
Yeah.
utterly confident our council, if given the opportunity to see something, will read it.
Okay. Thank you, Mr. Hepler. And can we move on to, let's move on now, we will move on to Agenda Item 6, which is discussion and consideration of teleconferencing options for medical board meetings. And Ms. Shipsky, Ms. Kirkmeyer, Mr. Hepler are going to walk us through.
Can you hear me? Oh, no, that's a little teleconference joke there.
Can you sit up at the table?
Right.
Teasing, go ahead.
Actually, having the last board meeting, sitting and watching you on Ustream without being able to communicate with you all, I feel the pain of those that would like to do that while we're on when we're in session, so, yeah.
If you'd please turn to tab 6, which is on BRD 6-1 and 6-2 in your packet. At the last meeting, we presented 4 options for allowing individuals who are not physically in attendance at a board meeting to be able to make comments to the board. Those 4 options were presented, including a telephone number for individuals to call in and listen to the meeting and make comments, allowing meeting to 3 locations throughout the state via video conference, and teleconferencing to specific locations throughout the state. The board requested Ms. Shipsky and I discuss these options in more detail and come up with some viable options for the board to use to allow public comment from individuals not at the board meeting. In discussion with Ms. Shipsky, it was determined that there really are 2 viable options for the board to consider. The options are listed in your packet. The first option is to allow individuals a telephone line they could call to either make a comment to the board or they could listen to the meeting and make comments. Individuals would have the option of watching the meeting on webcast and then only calling in when they want to make a comment, or listening to the whole meeting via the teleconference line and then making comments at the appropriate time. We would actually have a moderator that dealt with it, and they would actually authorize those individuals at the appropriate time to make comments. The issue with this option is that the time that could be incurred to hear from all of the individuals at the meeting or then also on the telephone. Legal counsel has stated that the board has the authority to limit the time afforded for public comment. So, for example, the board could state that it is going to allow a certain number of minutes for individuals at the meeting and the same number of minutes for individuals on the conference line. Each speaker, whether in person or on the phone, would then be given 2 minutes to provide his or her comment, and at the end of the comment time, then the board would move to the next speaker. At the end of 20 minutes, the public comment period would end. As stated in the memo, limiting the time allocated for public comment on any agenda item is a change from the board's current practice of appointing time per speaker rather than for the complete public comment period. Under current board practice, each commenter gets to speak, but his or her time is limited. The second option is to provide an email account whereby an individual watching the webcast could submit written comments or questions to a staff member who could monitor and read the comments or questions to the board at the appropriate time. Again, the board could impose limits on the time it will take to allow these comments to be read. Per legal counsel, if the board institutes the time limit requirements equally for those present at the meeting and those joining remotely, regulations may not be necessary, but again, they are recommended as stated in the memo. The board would need to be very strict in imposing time limits. The board may choose to pilot one of these options at a committee meeting before implementing at a board meeting, at a full board meeting. The cost for either of these options is minimal, but would require staff to monitor either the phone or the computer. And then Ms. Shipsky, do you have anything to add?
Yeah, I want to thank Kim for the hard work and other staff and for council for weighing in on this. The bottom line is that this board has indicated that it would like to find a way by which people can participate if they're not able to come on site for a medical board meeting. And one of these provisions would provide that, again, in the spirit of the regulation of open meetings and public participation. The timing, I understand, would have to be equally allocated between those that are here and those that would be calling in. But I do think it would be well worth our while if we could attempt a pilot. I think that might be the best way to see how it works and see actually how much participation we would have, and also how much staff time would be involved in having to deal with the calls that come in. Some local governments are trying this. We haven't tried it yet in Long Beach, but what we do allow is we do have live streaming of our council meetings, and individuals can actually contact the city clerk online with a comment, and that comment is shared with each of the council members, but they don't get a moment to orally present, and so that this would add a function to that by allowing individuals who wanted to go in teleconference mode to communicate with us directly. So I would ask the board to give this consideration and authorize a pilot to see how best we can work this out to further open up access and participation.
What a fantastic suggestion from the standpoint of carbon reduction, efficiency, less travel, very thoughtful, and kind of the way the world's going. So thanks for all the hard work, staff, and Jerry, I think that's pretty cool. I'm sure a pilot's probably the way to test it, because, again, there's always a little bit of failure with creativity, and hopefully find a solution that really fits the bill through the process. So I think that's pretty good.
What, were you recommending?
I'm making a motion that the medical board approving concept teleconferencing and allow a pilot effort to be launched with the direction of staff so that we can test this out and see how best we can open up access to the meetings offsite.
And just clarifying, piloting each option and seeing which
No,
one?
I would strongly recommend the first option. Let's see if we can make it work. The email option is very cumbersome, and it also becomes a public record. And not that we're adverse to that, but that's one more public record that has to be compiled and provided. And so if we can do the teleconferencing, that might be the best.
So
And people are getting more comfortable with teleconferencing, so I think that the email's a little bit behind that time.
So do I have a second?
I'll second it, but with the caveat, I want to understand that this is not a teleconference means there's a two-way street, a two-way dialogue. What we're talking about is opening up access for the public to have comments and to watch, correct?
Correct. We can't make
I want to make
dialogue
sure that
here.
the word conference is not part of the dialogue.
Well, actually, that's kind of the state-of-the-art term.
Well, in the city of Los Angeles, we have the opportunity
Yeah.
to be involved in city council meetings, and the public does come, and the public does offer comments, but it's not a two-way dialogue. It's an opportunity to offer, so maybe you want to survey other people that are already government entities that are doing this, but I'm going to second it, but I just want us to be careful of the term conferencing, because the physical, it denotes maybe more than we're expecting to do.
Well, I think, Barbara, that what takes care of it itself is the restrictions and the requirements for public comment, that we don't necessarily engage in a dialogue.
Right, I just want to make sure we're not going to be. That's
No,
my
no,
concern.
no, we're not. And then for the general public comment, we're not supposed to be dialoguing anyway, because it's a non-agendized item. So I think if we just would set out the rules very clearly, they would be consistent with a board meeting. But that would be using a
Right, I've seconded the
different
motion,
media.
it's fine.
Okay.
So discussion on the motion?
We have a motion, we have a second discussion.
Discussion,
Mr.
please, yeah.
Tagami.
I think, again, applaud the idea, the effort. There's clearly some work that has to be done, respectful of a world of inpatient desires that's placed upon our staff. I would, and I think that there's been good work done already, if we would recommend staff looking at how they would like to implement and make those recommendations and suggestions and bring that forward as they saw fit. Clearly, there are all these considerations that have to be thought through, as well as staffing and any other resource required that could impact budget. So they'll look at it and make some recommendations how they move forward. But clearly, taking it beyond this is something that I would be supportive of.
Dr. Gananadev.
I'm looking at it as a public comment by teleconference or telecommenting, so it won't be any different than coming here.
Public telecommenting, we can, thank you.
And you better register that, because now that's a...
Yeah, trademark it.
GoDaddy.com.
I'm going to add it to the lexicon of your Ganadevs.
And I just wanted to let you know that we have looked into this. We probably need to test pilot in our office, but we're very close to being able to do this because we actually have contacted our AT&T provider, and they will provide us a line that we can use. We had looked into some other options, but unfortunately it wouldn't be free for the public, which we don't want to do that. So all we would have to do is submit the forms to DCA and wait for it to go through. And then I'm hoping we may have a committee meeting, maybe at our next meeting, that we could test it at.
And I would suggest too that, I know our providers are doing, they're doing a great job with Ustream, so we certainly have to contact Ustream because they're being innovative about coordinating this kind of public access. So they also are looking into a audio component with Ustream.
Call the question.
Any other comments from board members, questions? I have several comments from public members. Jack French from Consumers Union Safe Patient Project.
Can I comment first, please? I think that is a good idea, though.
Sure.
Because I haven't heard that.
Again, my name's Michelle Montserrat Ramos. I'm a Consumers Union California Safe Patient Network, and I traveled here from Los Angeles this morning specifically for this issue and for Agenda Item 5. And, you know, I have to tell you that it took an extraordinary effort to get here. I asked for the teleconferencing option at quarterly board meetings in November 2010 and again in May 2011. The Consumers Union California Safe Patient Network has been urging the board for the past 2 years to begin teleconferencing your public meetings to allow for broader public participation. We are pleased to see that there is a recommendation before the board today to take action to provide teleconferencing at your meetings. The July 11, 2013 staff memo, teleconferencing of board meetings, discusses options for placing time limits on testimonies. We recommend that for now, the board apply a uniform per person time limit to people in the room and on the phone. We also recommend that the board make use of teleconferencing for a while before deciding whether there is a need to impose overall time limits on testimony for particular agenda items. The board's option number 2 is a proposal for emailing comments during a meeting. We recommend that you establish an email opportunity like this to be used anytime the board runs out of time for receiving oral testimony. Written comments can be emailed in during the board meeting and shared with board members during the public comment period, so no one's voice is left unheard. Thank you, Board Member Shipsky, for placing this item on the agenda, and thank you, staff, for the efforts you've made in making this happen. And thank you, board members, for considering opportunities to expand public participation at your board meetings.
Thank you. Mr. French?
Good afternoon. I'm Jack French from San Diego, California, and I support the teleconferencing option staff recommends. As a survivor of MRSA, there was a time that I could not travel and participate in NBC meetings. With teleconferencing in place, other Californians like me can participate in the important business of the board. Thank you.
Thank you very much. Tina Manessian?
Good afternoon, Board. Tina Manassian, Consumers Union, California Safe Patient Project. I also support the teleconferencing option that the staff members recommend. As a survivor of medical harm in 2002 from a doctor who was in the now defunct diversion program, there are times where I can't attend board meetings due to my injuries. With teleconferencing in place, other consumers like me can participate in important patient safety issues with the board. Thank you, board members, and thank you, staff.
Thank you very much. Any other comments? All right, and I think if there are no other comments, questions from board members, we have a motion on the floor to pilot the teleconferencing or the public telecommenting option for a committee meeting to be held between now and the October board meeting. All in favor?
Aye.
Opposed? Abstentions? So moved and approved. Okay, we'll move on to agenda item number 7, board member communication with interested parties. Do any members have communications with interested parties to report?
Madam
Dr.
Chair,
Ganadadep.
I do, as every meeting I report, I do continuously talk to AMA and CMA as I'm actively involved in it, but don't talk about the medical board.
And I think we clarified at our last meeting for informational purposes that the subject of interested party communication has to do with any communication that relates to issues that are or are likely to come before the board as opposed to general communication. So,
And Madam Chair, I'd like to point out that we're one of the few boards in the state of California that does this disclosure, and in the interest of openness and transparency, I'm very glad we adopted that.
thank you. Okay, moving on to Agenda Item 8, President's Report. And I was not, because of time limits at our June 4th meeting, I did not provide a President's Report, and so I do want to just enter into the record that since our meeting in April, I met, subsequent to our Sunset Review Report, I met with the previous chairs of both the Senate and Assembly Business and Professions Committee regarding the Sunset Review of the board, issues that were raised by the Sunset Review, and spoke at great length with both committee chairs, both of whom have subsequently been replaced. So we have new committee chairs on each of those committees of jurisdiction, and we'll be setting up meetings with them in the near future. And Dr. Lowe and I, as you all know, presented at the Senate B&P Committee hearing on SB 304, our Sunset Review Bill. On July 21st, I sent a letter to the chairs of the Senate and Assembly Business and Professions, providing an update on actions the board has taken and the board's desire, representing all of our board members, to ensure that we are moving forward to meet every concern of the committees, and not only taking action, but are clearly communicating to the legislature and the committees of jurisdiction the actions we're taking. And restating again our commitment to our mission of consumer protection. Since our June 4th board meeting and Ms. Kirkmeyer's assuming the role of interim executive director, she and I have had calls every 2 weeks with the executive team, going over issues and providing me with updates on board activities, status report on the work of staff, and it's been extremely helpful to me. I also have some, I wanted to include, in my last report, I had intended to include information that I thought was important for the board to hear about the Federation of State Medical Board meeting in April, but we've got an agenda item dedicated to that, and so I will include that. Any questions from board members? And just to be sure, board members know Senator Curran Price was elected to LA City Council, and Senator Ted Lieu has taken over as chair of Senate Business and Professions Code, and Assemblyman Gordon has moved from Assembly B&P to Assembly Rules Committee, and we have a new chair of the Assembly B&P Committee.
Yes, Assemblymember Bonilla.
Assemblymember Bonilla. And so any questions from board members, comments? I have a comment from a member of the public on the President's report. Mr. French?
I'm here on behalf of the Consumers Union Safe Patient Project, a nationwide campaign that is organizing patient safety advocates from across the state of California, as in the California Safe Patient Network. We see included in the materials for this meeting a document titled Standing Committees, Task Forces, and Councils of Medical Board of California, which includes a note that describes the Executive Committee of the Medical Board and says, quote, "Note, there should be at least one public member within group of 5 members," unquote. We urge the Medical Board to change this policy that only 20% of its Executive Committee need be public members. It is clearly the intention of the legislator that public members be much more heavily represented in deliberations of Medical Board. As you know, California law requires that 7 of 15, nearly half of the Medical Board members, be public members. We recommend that the Medical Board set a policy that requires that all committees of the Medical Board reflect a balance similar to that required by the legislature for the full Medical Board. We appreciate your attention to this. Thank you.
Thank you very much. And anticipating our next agenda item under Agenda Item 8A, Agenda Item 8A, I want to announce some changes to the board committees. Ms. Pines, Denise Pines, has graciously agreed to serve on the Education and Wellness Committee, and we appreciate her willingness to do so. Her background in media, marketing, communication, and public education will be enormously valuable to us. Dr. Yip has graciously agreed to serve on the Enforcement Committee, as has Mr. Tagami. And with Dr. Lowe's term expiring at the end of this month, Mr. Serrano Sewell has agreed to chair the Enforcement Committee going forward. Dr. Yip will also be added to the Special Faculty Permit Review Committee with Dr. Lowe's departure. And I just want to clarify that we have a prescribing task force that Ms. Yaroslavsky and Dr. Bishop are the board members on that task force, which will be convening sometime, I believe, after Labor Day. Will be the first meeting of that. And I'm bringing something also to the board. In looking at the functions of the board, discussions with executive staff, and the work of the board distributed among our committee members, I'm looking at kind of trying to consolidate some of the work. And I'm recommending to the board that we incorporate the budget subcommittee, the full board evaluation subcommittee, and what was a strategic plan creation subcommittee, as opposed to the executive committee's role in overseeing execution of the strategic plan, into what, for the moment, we've called an organizational effectiveness committee, essentially looking at budget, full board evaluation, and any necessary revisions and changes to the strategic plan in light of our sunset review and the work that we've been doing subsequent to the sunset review. And like all board committees, this will be a committee of two, and I've asked Mr. Tagami to join me in working on that committee. So submit this to the board as a recommendation. Any questions or comments?
It's your will, you don't, you
Well,
just-
I'm not asking for a vote, I'm just,
Good, okay, just
I'm
make sure you were not
interested
asking
in,
for me.
I just want to be sure, I'm open to.
Madam Chair, I'm just looking at full board evaluation subcommittee. What is it? One person on it. I'm just curious what it is.
I think Dr. Salmonson, who's that?
Well, I think some of that, I'd consider it more ad hoc. It had specific kind of projects, and it seemed to be totally tied in with when we were developing the strategic plan. So I think the consolidation now makes a lot of sense.
And at one point, we had, it was actually when Dr. Gitnick was here a long time ago, we had an evaluation. It was done by Ben Frank. Many of you may remember it. His report ended up actually being more about VE and the enforcement process, but when it was originally started, it was supposed to truly be a full board evaluation that actually kind of got waylaid, I think, with the enforcement aspect of it. So that was what that was about.
So it's worth looking at all of our committees on a regular basis to ensure that.
Still relevant.
Yes. Great. Great. Any questions or comments from members of the public?
Could you just repeat, who did you say is going to be doing the special faculty permit?
Dr. Yip.
Oh, very good.
And I should have mentioned that Dr. Bishop has been appointed by the governor to serve on the physician assistant committee. And I forgot to mention that Dr. Bishop has been reappointed. Congratulations. We're delighted to have you with us for another term. And let's move on then to Agenda Item 9, the Interim Executive Director's Report. Ms. Kirkmeyer?
And I'm going to apologize in advance. It's kind of lengthy today because we have several items that we need to bring to the members' attention. Just in administrative background and what, some things that are going on administratively. As Dr. Levine said, we are having biweekly calls with Dr. Levine, with our executive staff. And one thing that we've done is we've developed a spreadsheet that is being maintained that actually keeps a status on all of the requests pending that are from the board members, either that come out of the board or via a call or a request from a board member. And so we put that together, and it's really to monitor the requests of the board and make sure that they're moving through as appropriate. And with that being said, I would like to let the members know, all of you received a copy. It was mailed out to all of the members. But on July 2nd, 2013, we did send a letter to Senator Ted Lieu and Assemblyman Gordon at the time, who was the chair at the time of the Assembly B&P Committee. And it basically was an update on the actions that the board has been doing over the last month, couple months actually, and the things that are moving forward. And I just wanted to briefly go over each of those items and say where they are on the agenda, just so you know what we're doing and so you're aware of the actions of the board. So the first one was regarding enforcement program enhancements, and as most of you may remember, the reason that came up was due to the overprescribing cases. We, of course, have SB 62 and SB 809, which will both be discussed tomorrow in Ms. Simo's legislative report, and we briefly stated that, as well as we have adopted and implemented a prescribing task force, and you're also going to hear an update from that task force tomorrow on the agenda. The other item that we put in that letter was the adoption of uniform substance abuse standards, and those were just discussed, and those will be moving forward to the next board meeting. The other item that was on there was Consumer Protection Enforcement Initiative positions. As most of you know, the paperwork has been submitted to the Department of Consumer Affairs for those positions, and Renee will give a brief update tomorrow on that item. Oversight of surgical clinics and outpatient surgery setting programs, that was another item that came up in the letter. And tomorrow you're going to hear, I think, a great update on where we are on that program, including update on the website. We've also met with the task force and we're moving that forward. So I think that you'll be very pleased with the status on that tomorrow. The other item that they had requested information on was stipulated settlements below the disciplinary guidelines. Not only will members be having a training tomorrow regarding the disciplinary guidelines and the use and application of those, but also the administrative law judges have had training on this, and I believe Renee may give a little bit more information on that. And then the last thing next to last thing, was the use of interim suspension authority. As most of you know, that there is a bill right now to extend the length of time to file an accusation. That's in SB 304, excuse me, and I believe also in SB 809, 670, sorry. And I'm looking to Ms. Smells over there, who's giving me dirty looks. Anyway, and so there's going to be changes with that ISO process, and we're going to be having training by the administrative law judges in October on ISOs and how they view them, as well as we're also looking at training also. The ALJs, I believe, have had training on that as well. And then the last item that was of interest to the Senate and Assembly B&P committees was utilization review. And as most of you know, that was actually heard at our April board meeting. The staff heard very clear that the board wants to move forward, and that is the practice of medicine, and we want to move those cases forward. And the Central Complaint Unit staff have been trained by Ms. Katie on how to look at those cases to ensure that we're moving those that are quality of care cases through the review process and ensuring that we're not closing those as non-jurisdictional. So those were the items from that letter, and we're just real happy that we were able to provide that letter to them, and we'll continue to update both of the committees. On June 12th and July 15th, I met with the DCA director, Denise Brown, to provide her an update on the board, and have set meetings with her every other week, as well as with Ms. Lawley now. So I'm glad that she's aboard, and we have a great working relationship. Ms. Castro and I have biweekly meetings to remain up to date on items of interest between the board and the Attorney General's office. And we continue to have weekly calls with the department regarding the BREEZE implementation. Ms. Somoza and I met with legislative staff from the Senate and Assembly Business and Professions Committees to discuss the board's sunset review and to provide an update on actions the board has taken. Ms. Threadgill and I met with DCA executive staff and personnel staff to discuss the board's request to pursue pay differentials for the investigators. This was an item that came out of the enforcement committee and the board. It was too late for this request actually to be included in current negotiation discussions, but we will be putting it forward to DCA for future consideration. Ms. Threadgill has confirmed that the Office of Administrative Law is continuing to do their training. Ms. Simoes, Ms. Hawkinson, and Mr. Shunke and I met with staff from the Department of Healthcare Services to discuss outreach to newly licensed physicians regarding fraud and how to prevent abuse of their license. And we have agreed to partner with them in several ways, including putting their brochure on protecting Medi-Cal against fraud, waste, and abuse into each new licensee packet of information from the board. We're also coordinating outreach events and possibly including a little blurb in Mr. Shunke's outreach to future applicants. They're going to be presenting a presentation at the October board meeting. And then lastly, Ms. Simoes, Ms. Threadgill, Ms. Webb, Mr. Hepler, and I met Tuesday of this week with the receiver and his staff from the California Correctional Health Services regarding the recent investigative report on female tubal ligation. We wanted to obtain information from them on the events surrounding the investigative report and discuss what the board needed in order to perform an investigation. The board will be working with the receiver staff to obtain the necessary information to continue its investigation. And those are the administrative functions. Moving on to staffing, we currently have received notification Wednesday that we will be able to hire student assistants and retired annuitants under specific criteria that must be met, including that they are mission critical, and there is a review and approval process. So we will be requesting retired annuitants to assist in background investigations, field training personnel, and assisting with our BREEZE project. The board, we're happy to say, is still at a 7% vacancy rate, which equates to 20 vacant positions. Of those vacant positions, we have 11 individuals either in background or pending a start date. If you take those into consideration, we actually have a 4% vacancy rate. My personnel staff are at a loss for words right now because they're so surprised we've never been at this rate before. And so they're very excited, and we're keeping them very busy in filling these positions. Then if you will move on to page 9, I'm going to move to my budget report, 9B, which is under tab 9 at BRD 9B-1. The board's fund condition is on page 9B1, and it shows the board's fund reserve at the end of this fiscal year is projected to be 4.3 months. The board only has a BCP request that was approved for this upcoming budget year, 13-14, and that was for the BREEZE costs. You will see the approved amount of $1,183 million under 13-14, and then yes, under 13-14, and then under 14-15 approved costs. You're also going to see there the approved cost for CARES. As you will hear from Ms. Simoes tomorrow, the budget bill included language that provided an appropriation for the new CARES system. All prescribing and dispensing licensing boards were required to provide funding for this new system. The board's portion, and you'll see it on the fund condition, was $848,000 in fiscal year 13-14 and $790,000 in 14-15. Ms. Simoes will discuss continued funding for the CARES program tomorrow when she discusses this under SB 809. The budget bill had specific language that stated the feasibility study report by the Department of Justice has to be agreed upon by both the DCA and DOJ. In addition, the DCA will work with the DOJ on the roles and responsibilities of each department as to the governance, development, implementation, and utilization of this system. DCA has held 3 meetings with the affected healing arts boards to discuss the current feasibility study report and the requirements of the system DOJ is proposing. Each board has been providing input into this process. So that's something new I wanted to let the board know, and that's in that process. The board will also be requesting 4 augmentations for fiscal year 14-15. These requests include BREEZE costs, funding and position authority for an Operation Safe Medicine in Northern California, funding and position authority for additional positions in the enforcement unit, and an increase in expert reviewer rates. All of these are necessary to continue to improve the enforcement process and to reduce complaint, investigative, and discipline timeframes. Based upon these new projections, including the 4 future augmentations, it appears the board will be within its mandated 2 to 4 months reserve at the end of next fiscal year, and therefore it would not be prudent at this time to consider any reduction in rates that was recommended a couple years ago by the Bureau of State Audits. Are there any questions on the fund condition before I move on?
2 things. One is that on the prison health care and tubal ligation, how can we get that info or that complaint or that information before it becomes a huge media article? So I'm just curious why it didn't come to us, or did we not see it, or it never came, or that's the first question I have.
The first time that we saw it was Monday when the article came out. I think the article actually came out Sunday, but we didn't see it until Monday, actually, when it came out. That was the first time we had seen it.
Yeah, I mean, we need to do something with the system to really make sure that we are aware of that's our job. I mean, so we can't perform our job if we're not even notified. That's what really bothered me. And the second one on cures is this going to make for any doctor who want to really look into cures easier, rather than now it's almost impossible to get to the cure system because it will just throw you out. It's not available.
Yes, this system and the requirements, and I'm going to look to Miss Katie there because she's been working really hard on the requirements. It is going to be a much better system according to the requirements that we're writing and putting together. We're looking at not only looking at the requirements that we need for us as a regulatory agency, but also for the prescribers and dispensers, what they need, and make sure that it's in the system as well. All right, then moving on.
Wait.
Oh, sorry.
So within your budget report and your savings, which is always very admirable, there's a balance that needs to be struck between spending money and doing our job and saving money and looking good. So if you were to have your druthers and there was more money, or there would be the ability to have more dollars to spend on like Office of Safe Medicine, what kind of money and personnel and staffing, have you done any kind of charting as far as in the best possible world, what it would look like for us to be more effective and efficient in a time frame? Can you just touch on that a little bit, please?
Absolutely. So if you look under the fund condition, almost towards the end, you'll see anticipated future costs there. You're going to see 2 items there, one for Northern Operation Safe Medicine. So what we want to do is we want to obtain a Northern Operation Safe Medicine unit. That will be 4 investigators, 1 office technician, and 1 supervising investigator. How that helps the board is that it takes out the investigations that are unlicensed activity that are currently with those Northern investigators, so they are able to focus on quality of care cases, over-prescribing cases, et cetera. So that's one thing that we've identified as a need. The next one down you'll see is enforcement enhancements. We've determined that we have a necessity in our central complaint unit, our disciplinary coordination unit, and also in the field and our expert reviewer program. So we're requesting 6 positions based on that information that we've obtained. So all of those will go through the process, the legislative budgetary process, to obtain those new positions. And that's what we've identified at this time.
So these positions, though, are a minimum of what you need to improve? Or is this going to make everything work perfectly well? See, my concern is that we've been so cognizant of the fact that we are, the state has been in a horrible financial state. We've had money taken to help the state out. We've had all these issues, but now the state is starting to turn around. The legislators are paying very good attention to what we are and not doing, what we are and are not doing, as well as the media is paying a whole lot of attention what's not being done as well. So I understand that you've got 6 positions and 6 positions that are going to make your life a little bit better. But is there any projected, if we were to go down the road and see the end of the tunnel, what other things you could, maybe for not this meeting, but in the future, maybe that's something that we need to look for, because I know I'm being asked, and you're going to be asked. If I'm asked, you're going to be asked. So I just would like to we should be starting to think about.
Those are the ones that we're looking at right now, and we truly believe that that's what we need. However, in looking at overprescribing cases, Ms. Sweet will be doing a presentation tomorrow about those units, and those are the positions that we also believe that we need, but those will go into the following fiscal year.
Okay, thank you.
Okay? Just due to time, I'm not going to
You've
go.
got-
Oh, sorry, Dr. Yip.
So, on top of it, 92% fiscal year completed. Our end is end of June or end of July? The fiscal year.
June 30th, July 1st.
June is the end of fiscal year.
June the 30th is the end of our fiscal year, yes.
So we look at the Attorney General service, a budget of 13 million, we spend 10, so we only one more month to spend. In the future, we move that investigative unit over there. Does it come from that number, or?
Well, it comes from several numbers. That item actually is for Attorney General item, for the Deputy Attorney Generals that we currently pay right now. What will happen is the money in personal service, I'm assuming you're looking at page 9B2. I want to make sure I'm on the same page. Okay. So you'll see up at the very top, personal services, you'll see salary and wages, and then a whole list of items under that. Our investigators right now are included in that area. They're also included by position throughout several of the items under operating expenses and equipment down below. So if, for example, travel, training, facilities operation, a lot of that also is paying for the investigators. Were we to go to the Department of Justice, were the investigators to go there, money would come from basically almost every line item on this page and be put into the Attorney General line item.
What go under Department Pro Rata?
Department Pro Rata is the money that we pay to the Department of Consumer Affairs for the services that they provide, which would be contracts. They process several of our contracts. It's for their legal counsel, Mr. Hepler and Ms. Dobbs, sitting up here. It goes for their personnel. They process our personnel work. Just several distributed costs, yeah.
Plus more, plus more.
Okay. And so I just wanted to go over just one thing on that page, since Dr. Yip has brought that page up, and then I'm just going to ask if there's any questions on the rest of the budget documents. But something that looks very odd on our current budget is if you look down there, you'll see other items of expense, and you'll see that we are $81,000 over budget, or 81,000% over budget. I want to let you know that we will be adjusting this line item on the next budget, on the next year. This actually is for items for our investigators when they attend post. And we had so many individuals in post this year that it just drove it totally opposite of where we are. And so we will increase that line item. So I just want to let you know it's not, we're overspending in one line item and we don't know. It's just very unusual this year. So we will be making that adjustment so it doesn't look so crazy in the future.
Good idea.
That's Peace Officer Standards and Training. It's the 16-week academy that they have to attend. Okay? And then I'm not going to go over any of the other budget documents unless any board member has a specific question. Okay. Moving on, I wanted to give an update, a brief update on the Breeze project. That would be 9C. I wanted to let you know that on Monday of this week, we were notified that the project team is currently projecting a go-live date for September 17th. In order to reach this release date, though, the staff of the medical board, as well as all boards in the Department of Consumer Affairs, must complete a significant amount of testing and on the new system and also on the data conversion process. As the board is already aware, the board has a significant amount of staff working on the Breeze project. This will continue not only prior to the release date, but will continue after go live due to the need to continue to test certain items. There's no questions on that. I'm just going to skip forward and an update on the sunset review. As Ms. Smoes will discuss tomorrow, the board's sunset bill is SB 304 and it is going through the legislative process. As you may remember, the Senate Business and Professions Committee had 39 issues for the board to address. Most of those issues are in SB 304. There are a few issues that were resolved and answered via the board's response to the sunset review report submitted in April. However, the board does have a few items that require the board to conduct research studies and also to hold workshops. Staff has prepared a spreadsheet to track these items and will continue to work towards resolution of the items that require this follow-up. And we can provide an update at the October meeting on where we are on those items. And that, I believe, concludes my report, unless there's any other questions.
Any idea when our $9 million is coming back to us?
So Dr. Gonna, the way that works, and actually if you flip back to page 9B-1, when our budget gets to where we're below our mandated level, which in this case, it is in fiscal year 14-15, it's projected in fiscal year 14-15, at that time, we will put in a request for that money to be returned to us, unless the state gets an overwhelming amount of money that we have, and then they're able to return those funds. Okay.
Any other board member? Any comments or questions for Ms. Kirkmeyer from members of the public? Okay, sorry. Moving on now then to agenda item 10. The title of the item is Report on History of Business and Profession Code, Section 2220.7, gag clause for board members. Just to remind board members, this issue came up at a board meeting, and a member of the public, a licensee, actually raised some questions about the gag clause, and board members asked for a reminder of what the issue was and the history of the gag clause. So we've asked Ms. Kirkmeyer, Ms. Threadgill to provide members with a history of the gag clause.
Actually, you had it right the first time.
Oh.
The history is going to be provided by Kim, and then I'm just going to talk about cases. A few.
Meyer, could you provide us with a history of the gag?
And it's actually in your packet under tab 10, BRD 10-1 and 2. And I'm just going to go briefly over the background of the legislative process. In the 2003-4 legislative cycle, Assemblymember Correa introduced a bill that would have done exactly what the board's current law requires in prohibiting a gag clause. And actually, let me just back up and give you a little information about the gag clause. This is actually in our Business and Professions Code. It states that a physician and surgeon cannot include in a settlement any language that says the patient cannot file a complaint or cooperate with the board, or any language that requires the patient to withdraw a complaint. If a physician does this, they're subject to disciplinary action. So that's what it means when we're talking about a gag clause. So in 3-4, Negrete and Correa, introduced a bill that would have done exactly what our current law requires in prohibiting a gag clause. However, it included the prohibition for all licensees licensed under the boards by the Department of Consumer Affairs, including the medical board. This bill passed out of the legislature, but it was actually vetoed by the governor. The following year, in 2005, Assemblymember Negrete and McLeod introduced a very similar bill for all of the Department of Consumer Affairs. However, again, this bill passed out of the legislature, but was vetoed by the governor. Finally, in 2006, the board sponsored a bill which was authored by Assemblymember Negrete McLeod to prohibit physicians only from including any gag clause language in a settlement. The board, during the past years, had heard from public members during public comment on the impact of the gag clause and what it can have on the board's ability to take disciplinary action against a licensee. With the board's mission of consumer protection, they decided they should request a legislative change which prohibited gag clauses. Therefore, they sponsored the bill. The bill was signed into law in 2006 and became effective January 1st of 2007. And Ms. Threadgill is going to discuss actions that have been taken since that implementation.
And I'm not going to take a lot of time. I'm just going to briefly mention that the board has alleged this violation against licensees in several actions. Usually, in one case, we found out about the a violation as a result of a 801 settlement report, and during the investigation, we discovered the existence of the confidentiality agreement when the patient's attorney declined to cooperate with the release of records, citing the confidentiality agreement signed by the patient when the civil case was settled. This case resulted in the issuance of a PLR to the physician for a violation of 2220.7. In another case that involved sexual misconduct, the patient and the physician entered into a civil settlement agreement, and when we sought the settlement agreement, the physician's attorney cited the confidentiality provision as a barrier to unlimited production. So an accusation was filed alleging multiple violations, including 2220.7. In another case, an accusation was filed where the doctor allegedly offered to pay a dissatisfied patient to settle the matter. In exchange, the patient would write a letter to the medical board recanting the complaint against the doctor and sign a civil lawsuit release of claims. And I'm just trying to provide you, this is not something that we've never done before. It's something that we try to be aware of, and it's charged whenever we find a violation.
Anyone have any questions or?
Yeah, just, is this only applied to physicians, nobody else? I mean, no other boards, I'm asking about attorneys and all the others, physical therapists, nurses, and everybody else. I'm just curious.
It did. It was just to physicians, that law. And I'm going to look at maybe Kurt and Dawn. I know, okay.
I will tell you that this kind of agreement is against public policy. And so even though physicians were entering into these agreements, when I was investigating, we would have to work a little harder to get the courts to break the agreement and order the records be released, but it can be done because it's just not good public policy to do so.
Dr. Ganadev, since that time, when I was at the department, part of SB 1111, which was the bill that didn't go anywhere, part of that was, again, a request to stop the gag clause, and again, that didn't move forward. So at this time, I don't believe that there's, Julie, do you know any other boards that possibly do it? Not sure.
Julie D'Angelo Falmouth from the Center for Public Interest Law. Just FYI, lawyers have been forbidden to use regulatory gag clauses in civil malpractice agreements for about 30 years. Physicians, since 2006, I believe it was a 2012 bill, AB 2570, Jerry Hill, that expanded the gag clause ban to all licensees of the Department of Consumer Affairs. So everybody is subject to this. May I make one other tiny point? There's a difference between a confidentiality clause and a regulatory gag clause. And the only thing that is banned currently is regulatory gag clauses. And the meaning of that is the clause prohibits the patient from complaining to you, the regulator. So the patient is gagged as to you. Can't complain, can't cooperate if the board finds out about the complaint or the problem, or has to withdraw a complaint. Confidentiality clauses typically tend to require the plaintiff to agree not to reveal how much was paid, blah, blah, other things like that. Those are still legal. It's just regulatory gag clauses that are now banned for all DCA licensees. Thank you.
And just to make one other point, ignorance is no defense in terms of signing a contract with a gag clause in it. So a physician saying, I didn't read the contract, I didn't know it was in there, is not a defense against the violation of the statute. Okay, thank you very much. Any other questions from board members? Any questions or other comments from members of the public? Hearing none, let's move on to agenda item 11, update on Health Professions Education Foundation, Ms. Yaroslavsky and Dr. Diego.
apologize, I just didn't want to lose it off my computer. We've had a problem in the Health Professions Educational Foundation with the number of people that we have as members and the ability to generate a quorum, therefore the ability to spend a whole lot of money. But in spite of that, it seems that staff has been doing a very good job. We have also actually this week a new appointee to that board, which is Dr., I can't think of his name, but he's from Southern California. I'll get you his name if, I can only read one email at a time on my computer. We did negotiate and sign an interagency agreement with the Assembly Committee on Rules for $2 million to deploy a minimum of 134 primary care practitioners throughout the state of California. We signed the first grant agreement with the California Endowment for $155,000 for administrative support, and we are currently in the process of submitting a second grant proposal for $13 million, which is due next month. There is also, we have released our electronic application forms for the California Healthcare CalReach program, and we found that one new application is initiated every 11.8 minutes. So in scholarships in progress right now, we have 381, loan repayment 709, MLAP, which is doctors through the one program is 5, and the Stephen Thompson another 2. So we're doing real well in getting money and putting it out there. The issue has been the ability to have meetings with which we can discuss what we're doing. So from the perspective of HPF, we're doing okay. We could always do better with more money and more members. So I think, and Dr. Diego, do you have anything to add? You're okay? If you wait 1 second, here's the name of the new doctor. The new appointee that was just done this week by the governor is Dr. Delvecchio Finley. He's the Chief Executive Officer of the LA County Harbor UCLA Medical Center. And he's been the Chief Executive Officer of LA County Harbor UCLA Medical Center since 2011. Previously, he was the Vice President of Operations for California Pacific Medical Center and the Associate Hospital Administrator for the San Francisco General Hospital from 2006 and 2009. So he comes to us with a wealth of activities in the public sector and serving the underserved communities, so we look forward to having him as part of an active member of our board. That's my report.
Thank you, Dr. Diego. Anything to add?
No, nothing to add.
Okay, thank you very much. Questions from board members? Any comments from members of the public on this agenda item? Great. Let's move on to agenda item 12. This is a update on the Federation of State Medical Board meeting that Ms. Kirkmeyer and I attended in April, which we were unable to present at the last board meeting due to time. So, and I want to just give a brief update on the meeting and then let Ms. Kirkmeyer add some comments. The theme of the meeting was the medical workforce, what regulators need to know now. The keynote presentation was a very interesting one made by a professor at the John F. Kennedy School of Government on the art of harm reduction, lessons from the world of regulatory practice. Dr. Sparrow, the keynote speaker, has written a book on the topic, and it was a very interesting look at regulation from two different perspectives, one of which was harm reduction, and the other of which was looking at regulation as a tool and an approach to improving whatever the industry or enterprise is that it is regulating. So two very different approaches, and strengths and weaknesses, and obviously his conclusion being that this is not an either-or world, that one needs to look both at from a consumer protection, harm reduction, but also looking at regulation as an opportunity to improve the performance and the public accountability of whatever enterprise and transparency, whatever enterprise is being regulated. There were three topics that I think discussed in both plenary sessions and workshops that I think are of importance to this board going forward. The first was the issue of multi-state licenses. With the growth of the telehealth industry and essential, and this is my personal opinion now, the kind of starry-eyed view of the big telecommunications companies that are getting into telemedicine or the technology of telemedicine. There is an interest in using this mechanism to provide healthcare remotely. And remotely means anywhere in the world. And so there have been 2 bills introduced in Congress, neither of which has gone anywhere, with the support of the telecommunications industry, to get Congress to enact a pathway to what is essentially a national license, a federal license. This has been a great topic of concern, as you can imagine, by the state medical boards, because it essentially, what it would do would be to separate the licensing function, which resides at the state, and the disciplinary responsibility, the enforcement responsibility, which resides at the state. And so after, my sense is about 18 months of conversation, every one of the states present at the Federation of State Medical Boards resoundingly defeated any support for, or opposed any support for the notion of national licensure, explored several other options that states might look at to enable, for example, there are states like Wyoming that have a dearth of subspecialists and are desperate for the ability to get specialty consultation from adjacent states, if you will, or from other states. And so the notion that was approved for exploration was the notion of interstate compacts. That is, the development of a model for Wyoming and Washington State, for example, to enter into a mutual agreement whereby they would deem for certain services consultants who could operate across state lines without requiring state licensure in each state. And that the states themselves would work out the agreements around enforcement, continuing medical education, et cetera, things like that. So I believe Kim's been contacted for her thoughts about what California thinks about this, the California Medical Board, but it's a nascent movement, but I just thought the board ought to be aware that there are commercial interests for more than just the telecommunications industries that are pushing toward national licensure, and I think very strong feelings on the part of the representatives of the state medical boards that consumer protection is going to be very awkward and difficult, other than if you go beyond state borders, and that as medical boards committed to consumer protection, that preserving state licensure is a critical thing. The second issue is the notion that Ms. Chang shared with us on a number of occasions, which is the pilot project that is just beginning on maintenance of licensure. This is an effort by the Federation to pilot in some states that were interested in doing so, an effort to parallel, if you will, the work being done by the American Board of Medical Specialties to create a process for maintenance of competency. Currently, most states have CME requirements. Not all states, actually, but most states have CME requirements. The requirements vary very much from state to state. The American Board of Medical Specialties has almost universally now moved from lifetime board certification to time-limited board certification. And from some of the boards, they've moved from an exam-based board certification to something called maintenance of certification. That is the requirement on an annual basis to engage in activities in 4 domains which demonstrate competency, quality improvement, learning around physician-patient communication. There are a number of dimensions that have to be documented on an annual basis. And many of the boards are moving away from the high anxiety once every 10-year exam, where people spend 2 months studying once every 10 years to pass an exam to maintain certification. There are currently about 878,000 physicians who are in active practice in the United States. 200,000 of them are board certified. Probably somewhere between 300 and 400,000 have either never been board certified or have let their board certification lapse. I'm sorry, between 300 and 400,000 have let board certification lapse or have lifetime board certification. So about half that number were board certified when I was young. Younger. And those board certifications are essentially for life, require nothing beyond the initial event. But many physicians who were board certified under time limited have let that board certification lapse. And then probably about 200,000 physicians who were trained at a time when the specialty they're actually practicing didn't have boards. So they're not eligible. They aren't now and never were eligible for board certification. And the maintenance of licensure issue is really focusing on those physicians who don't have the opportunity to demonstrate competency on an ongoing basis through recertification, either through maintenance of certification or an exam. The state of Colorado was interested in, and this is going to be a many-year effort, but the state of Colorado was interested in doing this because the medical board was interested in being a pilot because in Colorado, state law prohibits the requirement for CME, except as in essentially discipline. So the only time that Colorado can require CME, this is state law, is if the physician has been shown to be deficient by virtue of being disciplined by the medical board. So they're very anxious to engage in something that would enable them to move forward. So there, I think, a podiatry board, Colorado, and one other board are piloting this. And again, it's not ready for prime time. There was a fair amount of conversation about this, but it is something we ought to be tracking and looking towards, because I think, eventually this is going to be, the expectation is going to be that every physician, whether or not they're board certified, are either involved in maintenance of certification or maintenance of competency for the purposes of licensure. So no action required now, but something to look forward to. And then the third issue, again, just for our information and tracking, is that there has been a lot written in the policy world, in medical journals, a lot of conversation in state capitals and in Washington about the growing or the increasingly burdensome debt that physicians are leaving training with, and questioning whether the current number of years required for medical school and residency program are necessary to produce competent physicians. And so a number of the medical schools in the country are participating in innovative approaches to looking at combining the 4 years of medical school, and particularly in primary care. Most of these innovations are in primary care, looking at accelerating what is now a 7 or 8 year medical school training into 3 years of medical school, 3 years of graduate medical education, trying to do something about the cost, the total cost and debt burden. And while we don't have anything to deal with now, we did raise the issue in our sunset review that we may need to look at the requirements for licensure in California if some of the California medical schools or national medical schools are producing graduates whose technical graduation requirements don't meet what's in our statute. And again, no action required now, but something we need to track. Dr. Solomons?
Well, I can't help but comment to think that if you want to shorten training, I'd look at having a 4-year undergraduate degree. I believe England, certainly South America, seem to go into medical school much quicker. And I think maybe and also for the debt. I mean, you come out with $200,000 just from the 4-year degree. And I wonder if that would also be a place to look at maybe taking Chaucer is a bit of a luxury. And maybe they should look at getting into medical school sooner, because the training is so long, and I can't see that we need less time to acquire that, but unfortunately, being the well-rounded scholar with the big debt is where we could look at a couple of years of savings, both time and money.
There actually have been 6-year combined
Okay.
undergraduate medical school programs. They did very poorly. And not all, but most of them have closed because of lack of interest on the part of undergraduates in applying to them. So there are still, I think, 2 or 3 that are still going strong, but a number of the schools that began those programs in the 70s and 80s have shut them down. Lack of interest. But Dr. Ganadev?
Maintenance of licensure is a very, very slippery slope. How are you going to go with it? I mean, this is not that simple. There are so many additional burdens that actually cost put on the physicians to do these things, and just like recertification, some specialties like mine, I am certified in both general surgery and vascular surgery. Not only I have to do recertify, I still have to do additional maintenance of certification. And just imagine, it's not, each one is, each time you take a board exam, it's about anywhere $2,000 to $5,000. It's not just 2 months of studying. That's why it's pretty complicated. So I think we need to look at pretty carefully, because we have fairly clear CME requirements and additional requirements if we have any, and privileging in the hospitals have. So, I mean, there is a lot of things come into play rather than just jump on the bandwagon about maintenance of licensure, which really worries me.
And the notion is that it would not, for those who are involved in maintenance of certification, it would not apply. This would only be for physicians who are not involved in some form of maintenance of certification.
And they're required still in California to do 50 hours of CME.
Every 2 years.
Right. We can increase it, but I'm just telling you.
Yeah. No, I didn't raise this in terms of, there's something, action for us to take, but just
FYI.
information. Dr. Yip.
Sorry, just for the sake of discussion, not so much the medical board function of you. I grew up in Hong Kong, where the system, where the medical school, you start when you're 17, 18 years old of high school, and you finish in 6th year and still look like a kid. But it works only if the government hospitals has a big network like Hong Kong. I mean, here, it would be a resolution to all this uninsured patient we talked earlier is expand the government-owned hospital. If you have this 23-year-old kid come out to private practice, they're going to survive, not talk about paying debt. Okay, but it would be great help if the government expand the medical services, hospitals and all that, employ them for 10 years. And most of them do work for the government for 10 years. When they're about 30-something, 40 years old, leave the system and become private practice. That would make sense. But for us here, I don't think it's a good solution.
Ms. Kirkmeyer?
Just a couple things as far as the Federation meeting. I just want to actually jump on to what Dr. Levine was talking about with the multi-state licensure. What the Federation actually ended up doing is they actually ended up, in order for it not to be kind of forced down the state's throats, for lack of a better term, what they actually did is that the House of Delegates approved the expiration of the creation of interstate compact. And so that's what they're looking at, and that's what I've been contacted about, was that interstate compact. So as most of you know, the reason you can drive from California to Idaho to Nevada and be, under the same requirements that you can't speed and you can get in trouble and et cetera, is because actually there is a national interstate compact that allows us to do that. There's, according to what they've said, there's about 30 of them, which I have no idea what any of the others are, because I was surprised. Oh, water, that's right, water was one. And so, anyway, that's what they're looking at. And again, at this point, it's really just exploration into this and what it would look like and how it would come into fruition and everything. But they have sent me the information, and I haven't had a chance to delve into it and look at what that is. But I will go ahead and send that out to the members once I've looked at it, and I'm trying to see where they're going to go. So I will provide that to the members. And then I did just want to let you know that I am serving on the IAMRA's Physician Information Exchange Working Group, and we're trying to work. It's kind of odd because it's a international working group, and so you have individuals in, let's say, Australia who do things very differently than we do, and so it's kind of been interesting to try to put that together and try to help them and have them help us and try to get on the same page. And then I'm also working with the Federation on the minimal data set. And that's other boards that are trying to gather information, and we're kind of the leader in this because we do the physician survey, and we actually did a presentation at the Federation meeting on the survey information that we obtained. So I just want to let you know that I'm working on those two committees.
Kim, on those boutique areas, I think it is an issue. I heard many complaints from physicians around Needles, Boulder City, and Kingman. That's all Tri-City area. You have 3 states. Arizona, Nevada, and California. So, and many times they have privileges in hospitals in all 3 states. And just imagine the licensing, discipline, and applying to Medicaid in all 3 states. I mean, it is a hassle, but that's a boutique problem rather than allowing the national license, or that scares me to death, let me put it that way.
Yeah, because our requirements are pretty strict. Not the strictest, but they're very strict compared to others.
I want to remind the board as well as the public that that both Kim and Dr. Levine were in Boston for this meeting at the same time of the Boston Marathon fiasco, and thank you for staying the course and showing up. Really, I mean, it's to be complimented with what was going on there, but those of you that watched any of the meetings online, which is what I had to do because I wasn't able to travel, it was really interesting and amazing and informative, I think, as well.
Great. And any other comments from board members? If not, questions or comments from members of the public? Great. Then we're going to move on to agenda item 13, update on the Physician Assistant Board. Mr. Shunke.
Good afternoon, members. As you've heard today already, the governor appointed Dr. Bishop to the Physician Assistant Board in June, and he will fill the position for the physician and surgeon member, and therefore in the future, you get to do all of these reports. The PA board, yes. The PA board has taken a position on SB 352, which is the bill which would authorize a physician to allow a PA, nurse practitioner, or nurse midwife to supervise medical assistants when the supervising physician is not on site, and that is a support position. The PA board has finished the regulatory process for the healthcare events, the free healthcare events, and it's gone through the Department of Consumer Affairs and State and Consumer Services Agency, and the package has been submitted to the Office of Administrative Law and is waiting their approval. And I assume you have on your calendar for the next PA board meeting, August 26th, 2013.
Any questions or comments from board members? From members of the public? Seeing none, Mr. Shunke, can you proceed with the licensing, outreach, and education program report?
I will. In the 15 years that I've been with the medical board, I think we have just finished the smoothest and best crunch time, the July 1 crunch time, that I've ever experienced since I joined the board staff. We did have a couple of delays, very few delays, with fingerprints not coming through on time. But the last outstanding fingerprint result came in on Monday and Tuesday of this week, so all of those people have been licensed. And at last count, I believe that there are only 4 residence fellows, someone who needed a license by July 1 to start their training program, who is, for one reason or another, not licensed yet. And it's has been a spectacular year for me and for all the others. And I really want to give a shout out to Mr. Warden, and especially 2 of his managers, Ms. Aceto and Anthony Salgado, who have really pulled what they needed to do, pulled the resources to get these people licensed as quickly as possible. Myself, I finished orientation at all the major teaching hospitals this year. This is where I travel around the state just to give a brief introduction to all the new residents in California, whether PGY1s or upperclassmen. And I'm now starting in August, going on licensing fairs, starting the circuit. I'll be going to UCSF, Loma Linda, Arrowhead, Cedars, and all the others throughout Northern and Southern California. And that concludes my
Great,
report.
thank you. Any questions for Mr. Shunke from board members?
I just want to remind board members, especially since we have some new board members, that what Mr. Shunke does is it saves our behinds. He really is out there in the community, and he's making sure that these medical people are getting their applications in a timely fashion, that the staff at the medical schools and the hospitals know what is going on. They've got a direct conduit to us, and therefore they're, thanks to Mr. Warden and his staff as well, doctors are getting licensed in a more than timely fashion without the headaches that we've had and we have suffered in so many years past. But I would really urge you that if you have time, that Mr. Shunke probably will send out in advance times when he's going to be visiting hospitals or medical schools, and would urge you just to take an hour, hour and a half, 20 minutes, and stop by and see what he does, because it's this cultivation of a relationship that I think is what puts us ahead of the game 100%, that without his engagement in this and on our behalfs, we wouldn't be where we were in as good a shape as we are. So I wanted just to take a moment to urge people to come visit.
Great. Dr. Gananadev.
Just taking on, I agree with Ms. Jaslowski, but if we could do on the enforcement side what the licensing is doing on the prevention, I think we will do a tremendous job. That is reaching out to the doctors to really prevent them getting into trouble and hurt someone rather than just disciplining forever.
Dr. Salmonson.
Well, on that note, I must compliment Laura Sweet, who spoke to the plastic surgeons at their annual meeting, and really kind of based on like the 7 deadly sins, things that could get you into trouble. And I think it was well received, and I'd like to think it's a tribute to plastic surgeons who want to stay out of trouble who invited her, but she did a beautiful job and it was very well received.
I'd like to add that enforcement has been doing this for a number of years now. We frequently get requests to do presentations all over the place. And lately, I've been asking board members from the various areas whether they want to participate in those presentations. We have one November 2nd coming up, and then, Jerry, there's one in August that I don't know, now that you're an important person, I don't know. Oh, okay. But, and we will continue to do that. Terry just presented to physicians on, sometimes they'll ask for various topics. They'll want to know what we have, the latest, what's the latest we have on pain management, or how to arrest pain without getting arrested is one of the big topics. And so, and we will frequently do those.
I want to give Dr. Gananadev for planting a seed in my head about putting something in the new licensee packet that very specifically in 20-point type says how to protect your license. Basically based on this is a talk Dr. Gananadev gives every year to the residents, the graduating residents, and something that makes very clear that this is a very precious resource. Don't take it for granted, and here are the ways that you can get in trouble. Because I think, for many young graduates, they kind of see licensure as an entitlement until they run into a problem that they didn't understand was going to get them in trouble. So he gets the credit for the idea, but really, as soon as we issue a license, putting something fairly attention-grabbing in the packet that says, protect this asset.
On that as well, I wanted to compliment the staff, on the communication staff, on the newsletter, and using it as an opportunity for questions of appropriate or inappropriate practices, so that doctors reading the questions, we know what the problems are. By posing the issue of the problem as a question and giving the answer, it's another tool that we have to try and help educate how to not damage your license opportunities.
This is actually a good time to, a good time to push that, because every hospital in the country is pushing, number one thing they're pushing is patient safety.
Yep.
So this is a real good time that protecting your license comes along with the patient safety. I think it's very important it's a good time to really take innovative steps to do this one.
Dr. Yip?
Actually, I was going to save it to tomorrow, but when we talk about the prescribing and all that, this morning the judge actually had a good idea. I found out his son and my son went to the same medical school, same class. So before I met him, I had the idea that with the approval of the board, any board member in any part of the state actually go to school, the first and second year class, give student talks and case study, educate them how valuable your experience and license and what may go wrong and what may cost you if you screw up 5 years from now, 10 years from now, 15 years from now. He actually gave 2 talks at the medical school class already. He invited me to be part of it, so I was going to ask the board how do we go by it, since I may be going on as a board member. The second thing I was going to bring up tomorrow when prescribing and all those is that, like my experience in the hospital, when we get privilege, every so often we have to, for example, moderate sedation, we have to take an exam and pass it if you want to do that. So I'm thinking maybe every 2 or 4 years, 5 years, when we renew our license, we should have a online course that actually monitor the time that we took it. We actually have to take an exam and pass it. The pain guideline, the prescribing guidelines, and also the ethics. We need to remind ourselves, okay? I see so many DUI, sexual misconduct. We need to remind ourselves, these are the things that don't hug your patient, give them a kiss, okay? Things like that. I think we should remind them by taking the exam when they renew their license.
I just want to echo what Dr. Yip, and I apologize because he just hit something. I agree with you that in the beginning, when doctors first come out and they get licensed, that they need to know, but they are inundated by so much information, and hopefully they're so exhausted from studying that they haven't thought about everything that might go wrong, that could go wrong. But that exactly what Dr. Yip is saying, that after several years, and that we've got to find some vehicle to remind them. And whatever that is, I just wanted to support what Dr. Yip is saying, because that's when they need.
Okay, any other comments? Any comments from members of the board? Members of the public? Sorry. Okay. Seeing none, then we have one more agenda item. As I mentioned when we began this morning, or 2 more items actually, that we're going to hold the elections because we're not confident. We may lose a board member tomorrow. So we're going to proceed to actually hold our elections for fiscal year 2013-2014. And as is the custom, we will start with nominations for board secretary. Do I have nominations for board secretary?
Madam Chair, I would nominate Sylvia Diego for board secretary.
Do I have a second?
Second.
Dr. Diego, are you willing to serve? Thank you.
What is this? Yes.
All right.
It's a new-
Okay,
Is it blowing over there?
okay, all in favor?
Oh, no. Are there any other nominations?
Sorry, are there any other nominations? Can we vote now, or do we vote?
Yeah.
Okay, all in favor?
Aye.
Opposed? You don't get to vote. Sorry, okay.
Thank you.
Nominations for vice president.
Madam Chair,
Yes.
I'd like to nominate David Serrano Sewell for vice chair.
Second?
Second.
Mr. Serrano Sewell, are you willing, if chosen, to serve?
If selected, I would resign as chair of the enforcement committee to allow somebody else to take on that role.
Any other nominations? Well, I'm going to nominate Ms. Shipsky. Okay. I had a second, right, Dr. Gannett? All in favor?
Aye.
Opposed? And nominations for president.
I'd like to nominate Sharon Levine to continue this year as president.
And I'll second that.
I saw that you did, Phil Tagami took a breath, so I had an opportunity.
I'm hoping there are other nominations.
And I was going to
You
be your
can't
second.
breathe, you can't breathe here.
Other nominations?
I have finally had to breathe.
Third call.
Not to nominate anyone else, but to say that it's been I know, I probably speak for all of us, but all my interactions with Sharon Levine have been positive. And people ask me, because there's been a lot of stuff in the press and all this and that, and I've always said, Dr. Levine is someone who operates at the highest level of integrity and ethics and professionalism. And that doesn't always serve you well in the public, It serves you well in the public, but when you're interacting with third parties and it gets contentious, people don't understand the true intent. And I think for continuity and where we need to go for this next year, we'll well serve with Dr. Levine.
Oh, thank you, it's very sweet. Okay, all in favor?
Aye.
Opposed? I have to abstain, but, okay,
Vote for yourself.
all right.
Rule
Before,
one, vote for yourself.
thank you all very much for the vote of confidence, and it is my privilege to serve this board, both in good times and difficult times. Prior to recessing the meeting, I want to take this opportunity to recognize a board member, a very valued board member who served on this board from 2004 until 2012, Dr. Sheldon DeRousseau. Would you come forward?
Oh.
Like many of our board members who served for 8 years on the board, Dr. DeRousseau played an important leadership role in many aspects of his time on the board. And I want to call out, both as a panel chair, but I really want to call out his contribution in convening and putting some focus on what became the Physician Wellness Committee. At the time when the Diversion Committee was sunsetted by this board, Dr. DeRousseau was an important voice in saying we need to focus on understanding what we can do to prevent physicians from getting into a situation where impairment puts their license and their career at risk. He convened the Wellness Committee, he chaired it, and he was instrumental in bringing experts in the field to share their expertise with the board. He was elected vice president at the July 2012 meeting, served for until his tenure ended prematurely from our perspective. Again, thank you so much for your service to the board. I want to present you with this lovely plaque and give you an opportunity to speak, and then we'll take a picture.
Only 2 minutes, though.
Wait, the public gets 3 minutes. Why can't we have 3?
Thank you, Dr. Levine, and congratulations to you continuing your presidency. I'm happy to be here, and I'm happy to see some familiar faces and colleagues with whom I had the privilege of serving for 8 years. I'm grateful for that. It's been a long day, I know, and so I won't take up a lot of time. And And just want to say to the board, thank you all very much for the work that you do. It's a work of labor and love, really, from my perspective. And you need to be congratulated and committed for your dedication. I also would like to recognize the staff as well for the work that they do in supporting the board. It's very important, I think, for the board and staff people to work together as a team to make the board what it is, and I think that's important. And lastly, I want all of you to know that how much I appreciated the opportunity to serve this board for 8 years. It was probably, and looking over my life in many respects, one of the greatest things that I thought I could do. And I hope that the small contributions that I've made have been positive and will serve the people of California. Thank you all very much.
Thank you.
I wish it were solid gold.
Oh, that's fine. I've been fighting for it.
But you are.
There you go.
Okay, look at the other camera. This one right here. Who's this beautiful? Oh, there she is. Now that she moved.
Thank you. Just one comment. I didn't get a chance to introduce my daughter.
She looks like her mom.
Yeah. Sheila said she was something important.
Thank you so much.
And we are adjourned, and I want everyone to notice it's 30 minutes before we sit.
That never happened yet.